Sounds like Mr. Dads might not be joining this afternoon, apparently. Is that your understanding?
Okay, it's 1:15 and the inquiry is resumed. Yes, if somebody could find out, because if Mr. Daz isn't attending the session, then I'm not starting the session late because he's not back. So
he has, yeah. I think this is all his stuff.
Okay, Mr. Simons, would you like to?
Thank you very much. I've got a list of a few extra documents. If you'd like them now, I can certainly give you them.
Yes. Can I just check? You said 2 to 2.5 hours.
Correct. So you've got all the documents Miss Ollie referred to. I don't know whether you'd like me to repeat them.
No, I've got those.
And then in addition, then officers report, first officers report, which is called document 3.3. 2014 Greenbelt study, called document 8.46. 2017 Greenbelt review, called document 8.1. 2018 Greenbelt topic paper, that's called document 8.2. Almost there. 2018 emerging withdrawn plan, called document 8.3. And then just 2 application documents. The DAS, which is called document 1. Can this be right? I think it is 113, 1.113. And then the TA, just because it's got a helpful plan in it, not for any transport reasons, it's called document 1.125. So let me know, Inspector, if you want to take a moment to sort of start downloading any of them, or if you just like me to kick off, I'll
no, you can start, and I'll do it
as we go. Yes, of course. All right. Good afternoon, Mr. Reynolds. Now, we're going to just discuss the scope of your evidence, what your objection is and isn't actually about first. Then some questions on the Greenbelt evidence base that the council's accrued over the last decade or so in support of its withdrawn plan. And then some questions on purposes and some questions on openness. And that's it. So that's the menu for the afternoon. Okay. So first mini topic, then the scope of your evidence. So just to sort of take a step back and to be absolutely clear on what it is you're here to talk about and not here to talk about. Greenbelt designation, it's not a designation that has anything to do with landscape quality or landscape value. Yeah?
Yes.
You've confirmed your view that from a landscape point of view, so we'll come to Greenbelt obviously in lots of detail, but from a landscape point of view, there is landscape capacity. There's capacity on this site from a landscape point of view for residential development.
Yes, there is capacity, but it would still result in substantial adverse.
Absolutely. And to be fair, adverse effects, because of the way the Glivia methodology works, adverse effects are an inevitable consequence of putting houses on any greenfield site anywhere.
Correct.
The issues that you cover in your proof of evidence are, I think, exclusively, to be fair, focused on Greenbelt issues, not landscape character, Glivia, LVIA stuff.
That's correct. I do draw from some of those landscape baseline evidence documents where relevant to do so, particularly where they mention some of the characteristics such as openness, the sense of separation, and how the openness of the land itself.
Thank you. But there is no, and I know this is obvious, has been confirmed, but just to be absolutely clear about it, there's no character and appearance objection from the council through you as part of its case of this appeal. It's expressed as a Greenbelt refusal.
As far as I'm aware, yes.
Yeah. There's also no design reason for refusal either.
Correct.
So just to be clear on one of the things you said in your evidence in chief, if we just briefly take up the first officer's report, it's called document 3.1, just on this topic of what is between us or not between us. Called document 3.1 is the first officer's report. You tell me when you're there.
just loading.
No, not at all. Going to be cursed by some slow Wi-Fi.
It is open now.
Good, thank you. PDF page 30, PDF page 30.
Yeah.
Thank you very much. Do you have the heading on 30, site layout and open spaces?
Correct.
And if you turn over, we don't need to read it all out. This is where the officer started considering the issue of site layout and open spaces. Over the page, there's something called an initial concept sketch. Do you see where I'm at?
Yes.
Then at 5.3.9, do you have the sentence starting in order to ensure that?
I do.
We're told that in order to ensure that development of the site is well screened from noise and air pollution arising from the A127 to the south, and in order to limit harm to open landscape to the north, the existing tree belts to the south and west were also expected to be retained along with hedgerows on Dunton Road and incorporated into landscape buffers along these boundaries as proposed, with the use of the landscape buffers for multifunctional purposes to deliver open space, ecological and surface water management benefits is in line with the former draft allocation requirements. The provision of an ivy-clad acoustic fence along the southern boundary of the frontage with the A127 with the associated bund and enhanced planting seeks to provide some instant greening and enclosure for the site, although it will naturally take several years for new tree and hedge planting to fully establish, and should be installed at the earliest opportunity to benefit future residents. And then the next paragraph begins. The result is a high quality designed residential scheme that would respond well to constraints, boundaries, settlement pattern, etc. Yeah?
Yeah.
And there's nothing between us so far as those paragraphs go, because that relates to the landscaping and layout and design implications of the buffer, landscape buffer and the acoustic fence and the overall consequences for the scheme's design. And those are not matters that the council pursues.
The council do not pursue those, as far as I'm aware.
Yeah.
I did not write this report, so obviously I'm not aware of. I didn't write this section, so whether I would disagree is obviously something to be aware of.
I'm not sure it is, whether it's something to be aware of. You've not provided any evidence to the inquiry that disagrees with any of the points that are set out in 5.3.9 or 10. And the reason for that is because your proof of evidence is concerned exclusively with matters that relate to Greenbelt, not design, not landscape character, as we confirmed.
Within the LVIR, the Landscape and Visual Impact Review, which was undertaken for this site, which forms Appendix 1, that includes a list of recommendations that sets out how design could obviously be improved. And obviously, as I've outlined this morning, it is my opinion that they haven't, that those kind of steps to reasonably improve the design to help alleviate and mitigate that harm to openness has not been taken. So what the result is this design and this kind of description of the layout coming forward. And as you can see on that plan itself, that initial concept plan, you have a buffer there, which is going to form a barrier. And in itself, whilst we agree that it may reduce landscape and visual effects in LVIA terms and landscape terms, it will cause a reduction to the openness of the greenbelt. Yeah, okay. Let's just take this in stages. Well, I wanted to start with what the scope of your evidence actually is, because you produced the LVIR, but the LVIR is not your proof of evidence. The LVIR is a document that you produced, before the scheme was refused, before the appeal process began. Your proof of evidence is exclusively concerned with implications that this scheme has on the greenbelt. Yes. And your proof of evidence doesn't go into any of this at all. It doesn't go into design critiques. It doesn't go into landscape character issues. That's because the evidence that you're here to give for the council is exclusively relating to greenbelt openness and purposes, not design, not character and appearance. So in terms of openness, when we're looking at all of of those parts and elements coming forward as part of that site layout, we're talking about a spatial incursion, aren't we, into the greenbelt? So all of those constituent parts, whether they're landscapes or hard and soft, they're all inevitably going to have an impact on the openness of the greenbelt, which Mr. Chard agrees with in his proof as well.
I appreciate that, and I've not suggested anything otherwise yet. I'm just at the moment just trying to be absolutely clear. I've been through those paragraphs of the officer's report. The paragraphs that I went through weren't about openness. They were about landscape character to a degree. They're about design, really, weren't they? And I've suggested to you that there's nothing in your evidence to this inspector that actually disagrees with any of that. And I think the answer to that is yes. I don't know whether you're hinting that you might privately disagree with some of this stuff. I don't know. If you do, you've not been over it in your evidence in chief, because it's not in your proof of evidence and it's no part of the council's case at this appeal.
It is not, no. But obviously our thoughts are set out in the LVIR, and that forms my evidence as part of the spatial impacts of the openness.
Okay. Your thoughts as set out in the LVIR are set out at core document 8.45, which is the LVIR. You said it might also be appended to your evidence as well, wherever you've got it. 8.45. You were taken there in your evidence in chief. And you confirmed in your evidence in chief that essentially you still stand by this, if you like. So at page 22, this is where I think you went in your evidence in chief.
Yeah.
You confirm, actually, if you still start at 21 and we'll get to 22, you confirm at the bottom of 21, you there, madam? The final paragraph, final bit on 21, that you recognise this capacity to accommodate the development subject to landscape mitigation commensurate to its scale to reduce harm to landscape receptors, character of site and surrounds. Bottom of 21.
Yeah.
And on 22, there's a heading visual impact. And you confirm, this is right at the end of the visual impact section, that it's your view that those impacts that are of most significance are localised and can be mitigated to reduce their significance of effect.
In visual effects terms?
Yeah, that's the visual bit.
Yes.
And then your overall conclusions are, you conclude it remains your view, I think, towards the bottom of 22, right at the bottom right-hand corner of 22, that there is capacity, as you've confirmed already, for residential dwellings in the easternmost bit, and then over the page, which could assimilate without suffering detrimental effects on character. And the western portion could also assimilate residential dwellings with appropriate landscape mitigation in place.
Yes.
And just to be clear, the case officer's view was that the buffering, if you like, to the south constituted appropriate mitigation in place, as we've seen, wasn't it? Oh, sorry, that was. I was referring back to where we just were.
Yes, yeah. Yes, that is the case officer's opinion.
You also, although this was a landscape-focused review, you did say at least one thing that was relevant to the Greenbelt case that I'm going to ask you about now, and that's on page 16 of the review, which is for document 8.45.
Yep.
It's under that heading, landscape susceptibility, on page 16. You tell us towards the bottom of that section, on the left-hand side of the page, just over halfway down, therefore a number of residential dwellings could likely assimilate within the landscape surroundings with mitigation in place, as we've said later on. And you also say, in line with the council's own findings, we agree that the development in this location could form an appropriate extension to Steeple View to form what you call a stronger edge to the green belt.
Yes, that's a direct lift from the council's own document.
But you've quoted it higher up the document earlier on, but now you're repeating it and you're saying actually you agree with it.
Yes, from a landscape perspective, yes.
Well, no, it's a green belt perspective, a stronger edge to the green belt.
It's
just to be clear, does it remain your view today that the scheme would form an appropriate extension to Steeple View, stronger edge to the green belt.
I said could form.
Could, but you think this one doesn't? Is that right?
That's my opinion, yes.
So you think that a residential development on this site could form a stronger edge to the green belt, but this scheme doesn't form a stronger edge to the green belt?
Not currently.
And what would need to change in your view in order for it to form a stronger edge to the green belt?
As I've set out this morning, some of the joined up kind of design considerations that would need to be taken.
That's exactly why I wanted to start with the scope of your evidence, because none of that's anywhere in your proof, is it? I mean, it's really not. You've given a green belt proof of evidence, but you've not gone into any design critique anywhere.
That wouldn't be required as part of an assessment of green belt openness anyway.
Right.
So,
and it's not what you've done.
Well, I don't. Yeah, I mean, I'm not looking at the design of it, am I? I'm only looking at the design coming forward and the implications that would have on openness. So
you're saying that your view here is that development could form an appropriate extension to form a stronger edge, but that our scheme does not form a stronger edge to the green belt. That's what you're saying, at least orally.
Within my LVIR, that's what it says.
No. What you're saying now, you're saying in your LVIR, we can read what it says.
Yes, I stand by my LVIR.
Yeah, okay. Moving on from that. So you've said in your LVIR that a development could, and now you're saying our development doesn't, but you've not expressed in your proof the reasons why it doesn't.
Because I don't need to express that within there.
But you haven't. If you wouldn't, the reason that this has taken slightly longer, if you possible, uncertain you were doing this at the beginning with a yes or a no, and then qualify if possible, if it's a sort of yes or no question, and then I can move on much quicker through the questions, if that's okay.
Yes.
Right. Let's have a look at the evidence base that the council has prepared over months and years that relates to the green belt and qualities of these of this site, and indeed of the wider parcel within which it sits. I think in time, we won't do every single one of these because there are loads, but I think the first one is October 2013, which is called document 8.46. That's the Greenbelt study from October 18. Sorry, October 3rd, did I just say 18? That's the Greenbelt study from October 13.
Yeah.
Thank you. Now, if you could turn in it, please, to page 205. That's paginated page 205. So on mine, it's actually PDF page 11. But anyway, paginated page 205.
Apologies, I'm struggling to open it on my system. Do you have a printed copy, Keith?
Yeah, go for it by all means. If it could be given you, that'd be. Yeah, I highlighted it's not ideal. I mean, there's a few pages I want to ask about though. Is it a clean one?
I mean, yeah, send me the link if you've got it.
Or... It's on that. I can't start sending you links. I've got loads of documents to show you. Sure. Yeah, go for it. Yeah.
Sorry, I've got my pages mixed up.
Yeah, no, don't worry. That's fine. That's it. That's fine. Thank you. You can be handed. You got it. Thank you. Yeah. Okay. So you're about to be handed it. This is the 2013 Greenbelt study.
Thanks, Keith.
It's called Greenbelt Study and its potential to accommodate development.
Yeah.
Have you seen this document before?
I have, yes.
Do you refer to it in your proof anywhere?
I do not.
Okay, let's have a look at it. The page to which I've referred you is a map of Area 20. It's paginated page 205.
Yeah.
So you see what Area 20 includes. I'll ask you more about this later, but obviously the inspector knows what Area 20 is, and you've helpfully provided your maps this morning, and it is, I'm pretty sure, same Area 20. It's a bit blurrier on this one, but anyway, it's broadly anyway the same area 20 that we talk about in other studies later on as area 20. So it's everything, if you like, up to that roundabout in the western extent of area 20.
Yeah,
that's what's being assessed. Right, a few pages of land use history, water risk, and all sorts in relation to area 20. Different constraints are ticked. And then we get on paginated page 208. Might be difficult if yours is actually not in colour. Yeah. I've just realised, but I'll explain what there is. Paginated page 208. Have you got area 20 greenbelt purposes?
Yes, I do.
There's a series of, on the right hand side, a series of red boxes, and you probably can't see them as red, but anyway, they are red. They're shaded red, which you probably see as grey. But it says in respect of each one, other than 5 on the next page, which is a green box, area 20 does not meet these different purposes.
Yep, I can see that.
Now, just to be clear, we're talking here about area 20. I said we are, the council is, right? Yeah, right?
Yes.
But that's a much wider area than the appeal site.
Yes.
So we need to be careful, because we can't simply assume that an analysis of area 20 in general applies in the same way to all bits of area 20 or to the appeal site in particular.
Yeah.
Okay. So the assessment on page 208, where the purpose boxes are set out, no contribution at all to purposes 1, 2, 3, or 4. Purpose 1, we're told, talks about the football pitches to the west, a few lines down. Then it says the area is heavily surrounded by major infrastructure. Yeah?
Yeah.
And at purpose 3, we're told the area is surrounded by a major road network, the A127 to the south, Dunton Road to the north. There's some ribbon development and a farm. As the area has development within it and is surrounded and includes some major infrastructure, it would be difficult to say the area was enclosed countryside. The open areas in the north beyond Dunton Road form a clear separation to where the countryside begins.
Yep, I can see that.
You can see that. I'll just give you 2 more references, then I'll just ask you something about it. On page 209 over the page, there's a section called conclusions.
Yep.
Do you see second paragraph that starts some of these constraints? The final sentence of that reads that Dunton Road, it's talking about the A127 in the previous paragraph, and then it says, previous sentence, then it says Dunton Road now forms a more definitive boundary in this area, especially as the land between the A127 and Dunton Road's low-lying and mainly flat, so as not to disrupt the views to the St Mary's Church, which is on a very steep terrain.
Yeah.
And where this all goes is, on the next page, 210, the area has the potential to accommodate development, we're told. Again, this is area 20, not our site. And recommendations, the area has potential to accommodate development in the eastern half. Development in this area will form a strong urban edge to the area of Basildon provided by Dunton Road. You see?
Yes.
And it's called right at the end of this section, a quote, primary area for development, which is supposed to be explored before other sites that are in tier 3, whatever that might mean. Yeah?
Yeah.
Now, so we can read all of that. We have been through all of that. That applies to area 20 as a whole. These are conclusions about greenbelt purposes. Yeah.
Yes. Yes.
Which were reached by this council about an area which includes the appeal site.
Yes.
And you've not analysed them or referred to them at all, even though you've told us that you were aware of them. You've not analysed them or responded to them anywhere in your proof of evidence.
No, this document is from 2013, as you've rightly outlined. I believe that this doesn't hold any weight, and I'm sure my colleague Keith Hargis will go through that in more detail. Yeah, I'm not sure.
Well, can I ask you about it? Because
yes,
if you say it's got no weight. What's changed that's material to the assessment of greenbelt purposes on the appeal site since this study was conducted?
So there have been subsequent studies of greenbelt review and greenbelt studies, and obviously we refer to the latest one in 2018 as a more reliable evidence base.
Yeah, I promise you I'm going to get to the 2018 one, because that's the one that recommended this site for release from the greenbelt. But just before we get to the 2018 one, Mike, you said that this study in 2013 you think has no weight at all, so much so that you've not referred to it at all or engaged with its conclusions. You say that, well, I don't know really why you say it. You say it's got no weight. My question is, what's actually changed on the ground, if you like, that's material to the assessment of any of these greenbelt purposes since this study was undertaken?
The site's changed in terms of like over time, so the boundaries would have changed.
Boundaries would have changed.
Yes, I mean,
Area 20. We're looking at Area 20, which
yes,
has got the same boundaries now as it did in 2013.
well, the boundaries would have changed since then. So the vegetation would have changed in the last, X amount of years, however long it's been. Some way it will be less. I mean, in here they're saying, if I can find that section, I mean, it was referring to the boundaries along Dunton
Right.
Road. But they are more regular than regular. I think it refers to them as being regular in here, but those boundaries along Dunton Road would be more irregular. If we break down what that boundary is along Dunton Road, we're talking about a unclassified road with intermittent hedgerows and a ditch and a verge.
Is this something that's changed? My question was, what's...
Yes, it may have changed over time. I don't know what the land would have looked like in 2013 because this hasn't carried out that.
Right.
So there may have been physical land changes to influenced.
Okay. So your view is that no weight at all, even though you're not aware of what the differences are, if there are any, that have occurred since this was produced?
Well, I have just outlined some of the differences.
Not sure you add. If you look at page 208, we're told that when it comes to purposes, that, for example, we've been over all of this just a moment ago, the area is heavily surrounded by major infrastructure, purpose 1. That was the case then, that's still the case now.
Yes.
We're told that the area is surrounded by a major road network. It's got development in it. Major infrastructure would be difficult to say. The areas in close countryside, open areas to the north, beyond Dunton Road form a clear separation, etc., etc. Nothing's changed.
Well, some of those, yeah, but the assessment has obviously changed since then. And
no, not the assessment. Are you aware of any changes on the ground? I know there's more assessments that we're going to look at, but anything that's actually changed? Because you're asking the inspector to give this assessment no weight at all. And at the moment, I've got no idea why that is so, because it seems to me, on the face of it, to be quite a relevant, detailed assessment that your own client undertook of an area which included this site, and nothing material on the ground has changed so as to cast its.
But the physical boundaries, the landscape boundaries.
Which ones?
So that to the north, as I've said, there's hedgerow, intermittent hedgerow. The condition of those could have deteriorated over time.
All right.
The vegetation along the southern boundary could have deteriorated.
It could have, but you're not aware of any changes.
Because I was not there in 2013.
Again, answer the question and then qualify. You're not aware of any changes, is that correct?
No.
Okay, thank you. Well, no, it's not correct, or no, it is. Are you aware of any changes that have occurred to the landscape since this?
You can't.
Please answer the question, then qualify, or else. That's what this is starting to slow down a little bit, and the reason is because these are simple questions, and you're I'm sure not deliberately going straight to a qualification without actually answering the question. So I'll try one more time, and then I'm just going to leave it and move on to the more recent assessment. So you're asking the inspector to give her this study no weight at all. That's fine. That's your prerogative, obviously. The inspector will reach a view on it. We do refer to it. We go into it in Mr. Chard's evidence, but that's for us to worry about, if you like. The reason is that you say, well, things have changed. Then when I've pressed you on it and I've asked you, are you actually aware of any relevant changes on the ground to anything that's relevant to the determination of impact on greenbelt purposes since this study was undertaken?
Well, yes, I would say the landscape boundaries may have changed over time.
No, not may. That's why I'm saying, are you aware?
Yes, they would have changed.
They would have changed.
Yes, there would have been a number of environmental factors for them to have changed over time.
You've just confirmed you don't know what they were like at the time this study was. I mean, come on. Excuse me, it's not a pantomime. Thank you very much. Not. Can you guess about things that might have changed? Are you aware of anything that actually has changed? Last go.
In the same way that you could.
Oh dear, you're not answering the question. I'm moving on.
Yes, then. Okay.
Yes, okay. Thank you very much. Righto. Thank you. You do spend time, not having gone into that study at all, you do spend some time on the 2014 Greenbelt study, which is called document 8.44. This one gets some airtime from you, even though it's only a year after. But anyway, obviously, has anything material changed since the December 2014 one?
I'll just get to that page.
Sure. You deal with it in your proof 3.2 and 3.3.
I'll just open that as well.
Now, 3.2 and 3.3 on page 13 of your proof, we get a couple of paragraphs on all of this, and there was even more on all of this in the abortive proof that came in this morning. This one's from as long ago as 2014, right?
This study.
Yeah. Yeah.
Yes.
This one you rely on. This one seems to get quite a lot of airtime.
Yes.
Strange, isn't it? There's only a year after the one that you give absolutely no weight at all. But this one, no material changes since then.
This study is undertaken a landscape character assessment and a landscape capacity assessment, whereby a landscape professional would have gone out and assessed the land condition, whereas that might not have been the case with the Greenbelt assessment. Oh,
okay. So the Greenbelt study that we've just looked at, it's not. It's the reason you give it no weight is because it may be that no one did a site visit. Is that what you're saying? The one we've just looked at.
Not just solely that.
Not solely that.
But yes.
Right. You got any evidence at all to support that? Are you guessing?
I'm not guessing.
Right. Okay. So where is it that you take that in relation to the 2013 assessment that there was no site visits done?
I'm not saying there wasn't a site visit. What I'm saying is that the assessment as part of the landscape capacity assessment would have been more detailed.
I think so. Okay.
That would have looked at the landscape condition in more detail than the Greenbelt assessment would have.
Okay.
And looks at obviously the landscape character, its features and its individual features.
Yeah.
Such as its boundaries.
Yeah. Okay. It's a landscape capacity study.
Yes.
The document at 8.44 to which you refer.
Yeah.
That's what it's assessing. And it's assessing, in this case, it's assessing area 20 as a whole, which starts on page, don't need to turn it up actually, but it starts on page 66. It goes over area 20 as a whole so far as landscape capacity is concerned.
Sorry, can you repeat that? Sorry.
This is a document, 8.44, the one that you're referring to, which is a landscape capacity study that deals with area 20 as a whole.
Yes.
But we agree that our site has capacity from a landscape point of view to accommodate residential development.
Yes, that's what the report did.
No, you say, you confirm that although this is a landscape capacity study, the reason I'm not going to bother going through it with you is because we agree that our site has capacity in landscape terms to accommodate residential development.
I agree with the council's findings in that capacity assessment.
Good. All right then.
We also must be aware of the other aspects that it refers to. You can't just take one point and accept that.
I was just saying you confirmed repeatedly that your view is that both the eastern and western parts of our site have the capacity in landscape character terms to accommodate residential development, and that was all I was asking you to confirm.
Yes, yeah. So I agree with the council's findings in that it says the opportunities for residential development are limited, and that is due to the openness of that area to the north of the A127.
All right.
And the barrier that forms.
That wasn't what I was asking about. That's fine. Right. That's, you deal with that. Then you turn on to the 2017 Greenbelt review at your 3.7 of your proof of evidence. So at 3.7.
Yeah.
And it'd be fair to say, actually, just for the inspector's note, I'm sure she's noticed this as well, that this 27 review comes up quite a bit in the assessment of your the other bits of your evidence later on. We get quotations from it and that kind of thing in italics. We'll come back to it obviously later.
Yes.
Just to note that this is the one. This is one that's repeated, that's dwelt on quite a bit. This is the document that is just, it's called document 8.1, and it contains, doesn't it, a Greenbelt review of parcel 20 as a whole.
It carries through the findings of that previous report.
Okay.
Yes.
I know we're not
Yes.
disagreeing, but
Yeah.
just answer the, please,
Yes.
please try to just give me a yes, because I think we agree. So just, it'll be a lot quicker, just move on.
Yes.
So we agree that the 2017 report analyzes parcel 20 as a whole and considers performance against Greenbelt purposes of the whole parcel. Yeah.
Yes.
And then that's core document 8.1. Core document 8.2 is the Greenbelt topic paper that comes a year later in 2018.
Yes.
And core document 2 zooms in. Core document 2, it's particularly at page 45 of core document 2, expresses a view not just about area 20 as a whole. Core document 2, page 45, looks at the appeal site in particular. And you refer to that too in your proof, obviously.
Yes.
Right, so this is the structure. The 2017 review is a parcel 20 document, as it were, just for shorthand, if you like.
Yes.
That's in 2017. And then the next year in 2018, we get a document that's actually focused in a number of sites, obviously, but including the appeal site itself, and not just area 20, but the appeal site on page 40, page 45 of 8.2, right? With me?
But can you repeat that last bit? You're saying the 814.
Sorry, I'll have another go. Let me just say it one more time, just so that everyone's clear about what these documents are and how they interact. The 2017 document at 8.1 was an assessment of parcel 20.
Yes.
The 2018 document, document 8.2, includes an assessment of this site.
Page 9, yes.
Page 45 as well. I don't know whether it's on page 9. Page 9. I'm not sure whether it is. Not page 9 on mine anyway, but yeah. Paginated page 45 of document 8.2.
8.2, yes. The appeal site was identified as site H9.
Oh, H9. I thought you said page 9.
I'm sorry,
I'm so sorry.
H9.
It was my... Yes.
H9,
that was
land
causing
west of
confusion.
view.
H9, exactly. So we've got one document that's area 20 wide, and then we've got a later document that's H9 focused, right?
Yes.
And we've agreed, haven't we, already, that we've got to be careful when we're looking at these documents, not to just assume that the parcel 20 conclusions can be pasted over to the appeal site.
Yes.
So it's useful then, helpful, that we've actually got a site-specific assessment to go along with it.
Yes.
Now, just to be clear, you cite both of these, obviously, in your proof of evidence in your section 3, that the 2017 one and the 2018 one. And you don't express any disagreement with either of them. As I understand it, you build on them and you rely on them in your evidence.
Correct.
Okay, so what we see in core documents 8.1 and 8.2, the inspector can take those bits as agreed, so far as you're concerned. Yeah, or not?
Yes, it makes the point that
No, I'm not asking you about what it's when we go through them in a minute.
okay.
Do you disagree with any of it?
No.
Okay, thank you. And obviously, of the two, if the inspector was interested in finding one which was most relevant, it's going to be the site-specific one rather than the area 20 specific one.
I wouldn't look at one in isolation.
No, I'm not asking you to. I'm saying that we've agreed, haven't we, that we've got to be careful about assuming that area 20 conclusions can be pasted over to site H9. We've got here conclusions that are specific to site H9, so it's obvious that the H9 specific ones are going to be most relevant. Not that the other ones are irrelevant.
Yes, I agree with that.
All right. So the most relevant ones are in most relevant conclusions are at document 8.2. But, and just again to just cut to the chase, when it comes to the purposes of the Greenbelt, which you deal with in your evidence at page 22. And also, to be fair, the openness of the Greenbelt that you deal with later on.
Yes.
There is repeated citation of the 2017 report and no mention at all anywhere of the 2018 report that's the most relevant one. Is there?
That's not correct.
Go on then. Get me to it.
So within section 6, you can see we have included the section from our LVIR, which looked at those purposes as well, from the Greenbelt review in 2017.
No. Hang on. Just do you understand the question? I know you've put that in for the 2017 stuff. My question is in section 6, which deals with purposes, and in section 7 that deals with openness, you refer repeatedly to the 2017 report. You refer nowhere to the 2018 report. So if the answer is that I'm incorrect, that's absolutely fine. Very helpful to know that. So just but if that's right, you have to take me to where in your proof you do refer to the 2018 report when you're looking at the purposes or the openness of the Greenbelt.
But this would be the changes that I spoke about this morning, the amends. So this is where I'd refer to my amended proof of evidence.
Well, you can't because it's not been accepted. But also, I don't think that's even. Well, I'm not going to start. I don't think that's right. But anyway,
I take your point. Obviously, that there are circumstances that I've explained.
I don't. If that is going to be your answer, then it might be that we've actually going to have another look at these amends. Because hang on, that is a very unfortunate answer, I've got to say.
So I don't want to cause any confusion.
You're saying that in the bits that you say you've not been allowed to put in, even though there's been no assessment of the more recent document in the proof that the inspector's got before her, you have done an assessment, have you, of core document 8.2?
Yes.
In section 6.
You can see I've reviewed it in that previous section that we went through.
You've not. You say you've reviewed it. Sorry, you say you've reviewed it. We already know that, and I've accepted. I've said that you've reviewed it, and you've confirmed that you have, which makes it all the more surprising. And I've just done a word search and just read through the proof that you were going to hand in today. There's no reference in section 6 or 7 there either to core document 8.2. You have not, when it comes to actually looking at purposes and openness, which is actually important things you're supposed to be giving evidence on, looked at what you agree with me to be the most relevant document the council itself has produced. You've not assessed it in your proof.
These are the typos that.
They're not typos, Mr.
So I should explain. I went on paternity before proofs were due, so I instructed colleagues to complete the assessment, although my proof of evidence. And so obviously I've only just come off of paternity leave as of last week, so that's why I've made the changes.
But the changes that you have made, which I'm looking at, and I'm not asking the inspector to get them out because I'm hoping we can short circuit this without the need to go back over whether this proof should be admitted or not. There is no reference. I don't know whether you've got it in front of you, and you just confirmed to the inspector in sections 6, 7 of which are the bits that deal with purposes and openness. There's no reference to core document 8.2, which is the thing that I'm trying to ask you about.
Oh, so yes, yeah, you're correct.
Well, then what are we talking about? Please just answer the question. There's no assessment in the existing proof or the proposed replacement proof at all when you deal with purposes or openness of the single document that we've agreed is actually the most helpful, relevant thing for the inspector to think about. You've not mentioned it in the existing proof at section 6 or 7 or the proposed replacement one. Even though you say you agree with it and you agree it's relevant and indeed more relevant than the 2017 one.
It is not more relevant than the 2017 one. I didn't say that.
You said that you've got to look at both of them, but you agree that of the two, it is the more relevant because it's site specific rather than area specific.
It is site specific, so it's useful because it builds on the previous report.
Okay, and you've not mentioned it. Can you just answer the question?
I haven't made a specific reference to CD82 in section 6, but it has been assessed.
It has been assessed. All right, fine. We'll come back to that one then when we come to the purposes. So no reference, but has been assessed. Lovely. Right. Okay, let's have a look at it then. This thing that you've referred to, not referred to, the thing that you say you've assessed but have not referred to in the sections of your proof that actually deal with purposes and openness. So it's core document 8.2, page 45.
Just waiting for it to load.
Don't you tell me when you're
What page?
It was paginated page 45, PDF page 49.
Paginated, sorry, what is it?
45. Paginated 45.
Oh, we're in a table, aren't we? Yes,
We are.
correct.
Okay, are you there?
Yes.
Good. Now, just to be clear, and we've already confirmed, you agree with all of this. You've confirmed, and you certainly don't express any disagreement with it anywhere. You correct?
Correct.
Good. All right. Now let's work it through. Let's work it through. Harm likely to arise then. So we're focusing specifically on H9 now. The area boundary, we're told in the third line down, is clearly defined to the north by Dunton Road and to the south by the A127 and by indeed existing residential development to the east, right?
Yep.
It should, however, be noted a few lines down from where I was there, so sort of 10 lines down, it should have been noted that this site, when viewed in the landscape, is set against a pattern of development which does extend further west to the south of the A127. So it's not necessarily out of context in its westward extent. Yeah?
Yeah.
The harm in relation to urban sprawl is not therefore significant when viewed in this wider context, but should be considered to be harmful at a local level. So that's the council's position, that's your position too. Have I understood that correctly?
I disagree.
Oh, right. Okay. That was wow. You have, just to be clear, I mean, is this an unfair question? I mean, you'd read this before you gave your evidence.
Yes.
And so when I've repeatedly asked you whether there's anything, I've asked you several times, whether there's anything in the council's evidence that you disagree with, you could have mentioned if there were any. This isn't some sort of trick question. You knew that this was going to come up, presumably. Yes. Something that you might be asked about, but yes. You've repeatedly confirmed that you don't disagree with any of it. And now when I actually read it out to you, you say, no, I do disagree actually. Yeah.
Yes.
Even though it's not mentioned anywhere in your proof of evidence and it's directly contrary to things that you've just told me. All right. So you think the council's got it wrong? Which bit's wrong? All the bits right that I've read out so far until that last sentence? Is it the last sentence that you think's gone where the council have gone wrong there?
I would agree that it's a visually open area of land.
Yeah. Now, which bit do you disagree with?
The harm in relation to urban sprawl is not therefore significant.
Yeah. Harm. So you think they've got it wrong there? You think the council's got it wrong there?
Yes.
Okay. And as to an analysis of what they've said and why you think they've got it wrong and your reasons for disagreeing with the council, the inspector's going to have to do her best to work it out because you've not set this out in your proof of evidence and you've not given reasons for disagreeing with it.
Not in that version of the proof of evidence.
Not in the other version either. You've not set out reasons for disagreeing with this.
I've expanded on those purposes and explained why it would contribute to that purpose.
Yeah, that again wasn't my question, but all right. Okay, so that's the first thing that you apparently disagree with. Is there any more? I mean, you have, as I say, are you familiar with this text that we're working through at the moment?
I am.
So, okay, is there any more of it that you disagree with?
No, I agree.
Okay, right, let's keep going then. So next, the site makes a contribution towards protecting the countryside from encroachment. It is nonetheless immediately adjacent to the A127 and contains ribbon development, which already constitute encroachment in the countryside. Consequently, the greenbelt area is currently considered to make a partial contribution towards this purpose, and development of this site would be less harmful in relation to the countryside than sites located in more rural locations. So we agree with that.
Yes, I agree that the site makes a contribution.
No, all of it. Don't read it all out again. We agree with all of that.
I disagree with the term ribbon development, where later evidence has referred to it as sporadic.
Okay. Do you disagree with ribbon development? Okay. Can I just ask you again, is there anything else that you disagree with?
No, I agree with what the rest of that.
Good. All right. So we agree that development of this site is less harmful in relation to countryside than sites located in more rural locations, nonetheless localized harm arises.
Agree with that.
Good. All right. Mitigation of harm. That's on the next heading. The use of appropriate lands. I should just say, is there anything else that you disagree with?
Not within that.
No, within the whole document. Come on, within the whole document on H9.
No.
Good. So we agree then that design and layout can minimise the impacts of development on the site on openness of the wider greenbelt in this location.
Correct.
All right. That's a good start. And we agree that the visual impact of development in this location, particularly, be minimised through the use of landscaping, which is already required along the A127 frontage for air quality and noise impacts, etc.
I agree.
So from this point of view, the screening, if you like, along the A127 that you picked up on for criticism in your evidence in chief, not only is it supported by the officers, it's in the case officers report, it's supported here too when it comes to minimising visual impacts of the development, and that's something that you agree with.
The visual impact, yes, it doesn't refer to openness.
Yeah, well, no, it doesn't in that sentence, but in the previous sentence, it says the use of appropriate landscaping, design and layout can minimise impacts of development of this site on openness.
They can. Whether this development can is another question, as I've kind of outlined earlier. 2 sentences,
both under mitigation of harm.
The use of appropriate, and it's like I said this morning, it comes down to the appropriateness of the landscape.
Yeah, it's pretty clear, isn't it, to be fair, that the use of landscaping along the A127 frontage is exactly what the council has in mind, and it thinks it's a good thing which is capable of minimising effects, both in terms of openness and visual impacts too, and that's the council's view.
I disagree, because in visual effects, yes,
right,
it would help soften the scheme, but the landscape mitigation coming forward emphasises that reduction of openness.
Okay. Role of the remaining green belt, final category or final heading. The remaining green belt in this location to the north will continue to function as currently in its purposes.
Correct. I agree.
And that we agree.
Yeah.
Okay. So the council's conclusions, therefore, are, with which you agree, that there'll be no wider impact on the greenbelt functionality of Area 20, of what is currently Area 20, if the inspector grants permission. The rest of Area 20 to the west will continue to function the way it does now in greenbelt terms.
The site makes a contribution towards protecting encroachment.
Come on, it's not my question. But again, do try and listen and engage with the question. I think you are understanding the question, but sometimes you're answering a different question. So you've just confirmed that you agree with the role of the remaining greenbelt bit. It follows, therefore, that we agree that the council's conclusions, and indeed your view, is the rest of Area 20 would continue to function as it currently does so far as its greenbelt purposes are concerned if the inspector grants permission.
The rest of the greenbelt, yes.
The remaining
exactly.
Exactly. That's it. Okay, good. Well, mostly is still on side with your client's assessment in 2018. Just to be clear, are you saying that anything material has changed on the ground since this assessment that would bear on harm to openness or greenbelt purposes, or can the inspector put a bit of weight on this one? I mean, you put weight on this one, presumably.
I do put weight on this one as well.
Yeah, so the inspector should too. So this isn't like the 2013 one, which you put no weight on. This one, the inspector can lean on a bit, if you like, in your view.
Yes.
Okay, good. And where does all of this go? It goes. Where did it go? I mean, it went into the emerging local plan, or then emerging local plan, which is at core document 8.3.
Yeah.
Where we were told, at core document 8.3, page 26. Yeah. This is sort of explains where it all ended up, the capacity of land within the green belt. And we were told, I'm not going to ask you planning questions, but just to put it all into context, we were told at 6.37, it was included that exceptional circumstances may exist I'm not going to ask you about them. However, it was necessary to make a planning judgment as to whether they do exist on a site-by-site basis, having regard to the suite of evidence. That's why I referred to it. So they had regard to, when they were reaching that view, the Greenbelt Study Review and a site-level Greenbelt Harm Assessment, which is the topic paper, and all, other stuff as well. Do you see?
Yeah.
And we're told, few lines from the bottom of this paragraph, sites which potentially risked the coalescence of Basildon urban area with Thundersley to the east and West Horndon to the west were considered to cause significant harm to the openness of the Greenbelt and the purpose of including land within it, and have therefore been retained within the Greenbelt, right?
Right.
So there's a particular concern the council's got about coalescence between Basildon and Thundersley and between Basildon and West Horndon, right?
Yes.
And obviously our site, because it wasn't proposed for retention, it doesn't play into either of those strategic points about coalescence.
Oh, I mean, that comes under that purpose too, doesn't it?
And then it's a 6.38, while some sites were excluded from consideration on the grounds of Greenbelt harm, just pausing there, obviously not us, but other sites were.
Yeah.
Some more significant incursions into the Greenbelt have been identified where there is the potential to secure significant transport infrastructure projects. Anyway, that's not to do with us, and those are much larger schemes that are detailed there. Yeah. So the council's position at this stage in the game was that there were no grounds on Greenbelt harm, Greenbelt openness, purposes, coalescence, whatever, to exclude this our site from their plan. No Greenbelt harm, reasons to exclude the site.
They didn't carry out, obviously, a site assessment to assess those the appeal schemes on the contribution to those purposes. But yes,
they did, didn't they? That's the document we've just looked at, the 2018 H9 appraisal with the table.
Oh yes.
Yeah. So there was a site-specific Greenbelt assessment, and on that basis, loads of sites were excluded, not us.
Yeah.
Okay. Thank you. Right. Now that's all very interesting. Maybe that's the background that has been studied for over a decade now. But what is your analysis of the reasons, notwithstanding all of that the scheme should be refused for Greenbelt reasons? So first, purposes. First, your assessment of Greenbelt purposes. Now, for purposes, we turn to page 22 of your proof of evidence, I think, which is section 6.
Yes.
Right. And just to be clear, sort of right from the off, if you like, you don't look at purpose 5 because it applies sort of strategically equally to all Greenbelt. Yeah. So you don't give any evidence on purpose 5. Purposes 2 and 4, there's nothing between us on.
Right.
So just to lay the table, if you like, from the outset, there are, as you've been very clear, 2 purposes, if you like, in dispute, and it's the first one and the third one.
Yes.
Right. Okay, so purpose 1. Your analysis of purpose 1 is contained at paragraph 6.1 of your proof of evidence, correct?
No. So that's just a context. That's obviously 6.1 is then this is where some of the typos might appear. So
don't worry about typos. I mean,
just before that, the real 6.1 is obviously the reference to the landscape and visual impact review, where we
okay, the real 6.1,
and then that's where it should continue as 6.1.
Oh, I see. Oh, okay, sorry. Right. So this is your. I see. Right. So you've referred back to the LVIR. I see. Yes. Okay, so I haven't rephrased the question then. So your evidence in respect of purpose 1 is contained at, well, but yeah, if we continue on pages, starting on 6.1 on page 20, and it ends at 6.1 on page 22.
Correct.
Your reference on page 20 in the italics is to the 2017 study, the 2017 Greenbelt Review, that you then summarise in the LVIR.
Yeah.
And your reference at page 22 to 6.1 there is again to the 2017 study which again, you sort of copy and paste in. Right?
Yep.
Which means that your proof contains no analysis at all of the appeal site itself, so far as purpose 1 is concerned. You've only looked at material that pertains to parcel 20.
That's changed in my amends.
Mr. Reynolds, right, you've accepted, the council accepted that proof of evidence is not before the inquiry. If you continue to still refer it during the examination, I'm going to have to, Miss Ollie, I'm assuming the council, we would have to have an adjournment, a formal adjournment, so that I can read the document. And you've already said that you don't want to do, you're not pursuing that.
That's right, because
Yeah, but the witness can't keep referring every response he's giving is saying, oh, well, I had answered that in my other document.
He cannot, ma'am, no.
Sorry?
He cannot, no.
Well, could you ask him to?
Oh, sorry, I would have done through you, ma'am. Yeah, I mean, please take the inspector's cue on that,
Okay.
Mr. Reynolds.
I will do that. Apologies.
Yeah. All right. I mean, in any event, it's right. It's right. I've got the document in front of me and it doesn't. But in terms of for the purposes of the rest of my questions,
yeah.
I'm going to have to, I mean, you know, right or wrong, but this is just, unfortunately, it is a process that we all prepare for. And I appreciate, you know, the situation that you've been in, but we've all got to prepare.
Yeah.
You've given the inspector no written analysis at all. And to be fair, there was no oral analysis either when you were just asked about things in your evidence in chief at all of the appeal site vis-a-vis purpose 1 rather than purpose 20, rather than parcel 20 as a whole.
Correct.
Okay. In particular, you do not mention the findings of the 2018 review that we've looked at and its conclusions that you've just for the first time 10 minutes ago said you disagree with, having said you agree with them, that any harm to sprawl is not significant in wider context, and if there is any, it's only localized.
Correct.
Not mentioned it, certainly not engaged with it. The findings of the 2003 study that found that Area 20 made no contribution to this purpose, not mentioned them at all.
Oh.
So if the inspector's interested in not what Area 20 is doing against purpose 1, but what the appeal site is doing in respect to purpose 1, she's not going to find it anywhere in your written evidence for this appeal.
Other than within the baseline, the review of the evidence.
In terms of your analysis,
my own assessment, not within this paragraph, no.
Or indeed any paragraph in your proof or anything that you've said orally. I mean, let's focus on your proof for now, I guess, to make it an easier question to answer.
No,
nowhere in your proof.
In this proof, no.
No. Okay, so you've not analysed it, you've not gone into it, you've not dealt with it. That's fine, but I suppose the inspector, you know, might be thinking, well, I've still got to reach a view on this one way or the other, or, you know, whatever you've said. And so just take out, I mean, we could go to lots of different places, but if you would, just for a convenient overhead photograph, could you take out the design and access statement, which is document 1.113. I hope this isn't too big a PDF. It might be. They sometimes are.
It's opening.
Lovely. All right, I'll let me know.
It is, yeah, it is open now.
If you turn to page 8, which is just a site description, there's an overhead.
Yeah.
Figure 1, site location plan. You got that, inspector? Let's let the inspector get that as well. Sorry, yes, exactly. Site photos, exactly. Site photos, location plan, the overhead picture,
yes.
Just so that we can see what we're talking about. The site it's contained by the A127 to the south, isn't it?
Yes.
By residential development to the east at Steepleview.
Yes.
By Dunton Road and Sellers Farm to the north.
Correct.
And indeed by Steepleview Farm to the west.
No, it looks like the boundary stops ahead of Steeple View Farm.
I would agree with that. Yeah, I mean, the inspector will see that on site. So it's not fully contained, but Steeple View Farm is to the west, which provides a degree of containment, albeit it's not contained in the same way as the residential development to the east.
But the boundary of the site that you've shown on that red line boundary isn't up to the farm. So there's.
I see what you mean. Right. Fine. In any event, we see that Steeple View Farm is immediately to the west of the site.
That's true.
Okay. So the 2018 study reminded us that there's already westward sprawl to the south of the A127, and we can see some of that on this image, can't we? Although there's more of it to come further west.
Yes.
And it was on the basis of that sprawl that when you were doing the further flung views to the north, looking back over Basildon, that the 2018 study found no significant harm to sprawl in this wider context. Do you recall?
Yeah. Yeah.
Is it really your evidence to the inspector that what we're talking about here constitutes unrestricted urban sprawl?
Yes,
it is, even though we've got containment by roads and houses on three sides and a degree of containment from buildings on another. I mean,
I can go into, if you like, so the existing western boundary that we're talking about is formed by the rear garden curtilages of residential properties along King's Road. They're largely defined by that boundary fencing. So, there's going to be a degree of inconsistencies and differences in the materiality and the condition of those fences. We've also got tree and hedgerow vegetation. I think it's worth having a look at the tree survey and arboricultural impact assessment, sheet 1 of 2, CD 2.1b. That shows quite a fragmented and gappy tree line and hedgerow, the majority of which is in category C, except with the exception of one tree, which is category B. So despite that irregularity, I accept there's a clear division of residential land use and open greenbelt. The greenbelt would clearly play an important role in preventing sprawl further westwards.
Okay, I'm not quite sure. Maybe it's my fault, not yours. That was an answer to the thing that I asked you. So, do you remember the 2003 study?
Yes.
Told us that we have steeple view in place.
2000 and what one? Sorry.
3.
13.
13. Thank you. Too many studies. 2013 study told us, do you remember, that Dunton Road now forms a more definitive boundary in this area than the A127 does. We've seen the reference to page 209 of 8.46.
Yes, they come to those findings.
Yeah. We're not extending beyond the existing built envelope of Basildon to the south, to the east, to the north, or indeed to the west.
This is coming out from the west.
That's what we've looked at. There's already sprawl from Basildon way further to the west.
To the south, but what you have to do is accept, if you're accepting the barrier that the A127 forms, that this is referred to within those reports, and even that 2013 one, that the A127 forms a barrier. So there's
loads of residential development already to the north of the A127, loads and loads, and those are the people who spoke this morning live there. Steeple View, and your view is that this site could be developed in such a way as to form an appropriate extension to Steeple View to form a stronger edge to the greenbelt.
From a landscape perspective, yes, not a greenbelt perspective.
Okay. But the point is that we're not, as I've said already, extending beyond the built envelope of what's there at the moment. There's built development to the south. There's loads of built development to the west, to the south of the A127, loads to the east, and indeed there's even built development to the north.
So the A127, it's perceptually perceived as a robust barrier.
Yeah, even though there's shed loads of development to the north of the A127
It's
already.
strongly and physically well defined. It's a permanent boundary.
Yeah.
And that prevents disproportionate sprawl from the south.
Righto. Okay, that's literally the opposite of what the council's own evidence base has found for the last decade, which is that Dunton Road is the appropriate barrier now, given the existence of Steeple View immediately next to our site and not the A127.
It doesn't state that it's the barrier, that it will form a barrier.
In any event, in the end, if the inspector were looking for a site-specific analysis of our scheme against purpose number 1, she won't find it in your written evidence.
Correct.
Okay, thank you. That's purpose 1. Purpose 3. Hang on 1 sec, let me just get out your proof of evidence. Purpose 3.
It's a typo, so.
Oh, is there?
Yeah.
Oh, okay. Yeah. Right. So page 22, there's a heading purpose 3. What do you mean there's a typo?
It's an extract from something that's not relevant to this.
All of it?
Yes.
So, okay, sorry, I didn't realise that. So 6.3, paragraph 6.3 on page 22, should that be excluded in its entirety?
Yes.
Right, sorry. Okay. Okay, right. So we put a line through that, as it were.
Yeah.
You do refer to purpose 3 at 6.6.
Yeah.
Nonetheless, so would it be fair then to say, given what you've just told us, that your analysis of purpose 3 is contained in paragraph 6.6?
Yes, for this reference.
This yes for this one.
Yeah.
Right. Okay. And again, when you come to consider purpose 3, you're talking about the parcel. As you explain at 6.5, you talk about Greenbelt Review 2017, the parcel brackets parcel 20, as well-defined boundaries, etc. And then you go on to talk about views across the parcel.
Yeah. And
then your conclusion is that the parcel partly contributes to purpose 3.
Yeah.
So just to be absolutely clear about it, so the inspector's not under any, misapprehension. There's no analysis here of the extent of harm to purpose 3 caused by a scheme on the appeal site in particular, as opposed to parcel 20 as a whole.
Yeah.
There's no reference to the 2018 assessment that we've looked at already from your own client, the council, that talked about as the site abuts the A127 and already abuts ribbon development, which encroaches into the countryside. There's less harm here to this purpose than there would be in more rural locations. We've looked at that already. I'm just paraphrasing it. I don't need to go, but you don't go into that at all.
Not within section 6, no.
No. Oh, okay. Not within section 6, not within anywhere.
It was in that evidence review. The way we talked about H9.
Sorry, no, you don't go into it anywhere in your proof of evidence. Sorry, that's what I meant. There's no analysis of the 2018 study so far as its conclusions on less harm than in more rural locations to countryside encroachment. You don't go into that in your proof of evidence. That's my point. Yeah. Okie dokie. So no assessment of the most relevant evidence base, no assessment of the site itself on the 2 purposes. That's that. Okay. What about openness? Openness, you deal with from page 24, section 7, impacts on openness. You deal with spatial openness on page 24, and then from page 25, there's a heading visual aspects of openness.
Yeah.
Okay. Thank you. Right, so I'll ask you about those in turn, if you like. Or the spatial, then visual. So spatial component of openness. Para 7.2, you quote from the framework. Para 7.3, you say that the site provides an important function in containing sprawl from the south and into open countryside, as stated in the 2017 Greenbelt Review. When you're talking about the site there, you're obviously talking about parcel 20 rather than the appeal site. The 27th Greenbelt review didn't look at the site; it looked at parcel 20.
You've acknowledged that it would have looked at the site as part of that anyway. So yes.
Who's acknowledged? Sorry, I've acknowledged.
You said that report would have looked at that site as part of area. Area 20.
It's obviously it's part of it, but the point is that the 2017 review is an assessment of parcel 20, as we've been over.
Yes,
maybe 15 times. The reference here to the site providing an important function as stated within the Greenbelt, the 2017 Greenbelt review is a reference to parcel 20, it would seem, not to the appeal site itself.
In paragraph 7.3, yes.
Okay, so 7. Well, I'm not trying. It's not like a sort of game of trying to catch you out. You've referred to the site here, but you've referred then to evidence base that's got nothing to do with the site. It's the whole parcel of parcel 20 as a whole. So when we see the site at 7.3, that reference to the site is in fact not the site. It's a much wider parcel of land that includes the site, but is not limited to the site. Correct?
Correct.
And then at 7.4, the spatial function of the site, you say, is an integral element to the openness of the Greenbelt. The impact development will have on the landscape of this location will, based on our assessment, fundamentally impact on the openness of the Greenbelt, right?
Yeah.
You said it'll fundamentally impact on the openness of the Greenbelt. That's your view, apparently, at 7.4. But when we have agreed about 5 minutes ago that the council was right in the 2018 paper that you don't even mention here, to find that the remaining Greenbelt will continue to function exactly as it does now. Correct?
Can you say that again? Sorry.
You're telling us here that this scheme on this site will, quote, fundamentally impact on the openness of the Greenbelt.
Yes.
It may be then that I suppose what you're meaning is just insofar as the site itself is concerned. I don't know, but I read fundamentally impact as referring to something sort of important that goes wider than just the site itself. But I might be overreading.
No, yeah, it's just the site.
Just the site itself. Fine, fair enough. Fine, thank you. Okay. Not in any part of this analysis refer to the site-specific conclusions of the 2018 study on openness. Conclusions that we've agreed on. Conclusions that, if you just turn it back up briefly, I don't know whether you've got it on, can put it on another tab or something like that.
What one was that? Sorry.
It was for document 8.2 on page 45.
Yeah.
Any luck? Yeah. We've obviously looked at this already a couple of times. Mitigation of harm. We see and we agree that this is a site where the impacts on openness can be minimized. Second line of mitigation of harm.
Yes.
And indeed, visual impacts can be minimised too, as we're told in the second. And on that, we all agree. And indeed, you've just reconfirmed this already. We also agree that with our site in place, with our scheme in place, the rest of the Greenbelt around and about will continue to function as it does now.
Yes.
Okay. Right. So capable of being minimised through design. Council has no case on design. Rest of the Greenbelt continues to function as it does now. Visual aspect of openness that you deal with from page 25. Of your proof, sorry.
Yeah.
Right. And this is here you give a sort of an assessment, if you like, of the site, of different views and different viewpoints and that kind of thing.
Yeah.
And this is all done with reference to what you call the site, quote unquote. It's 7.7 most of the site, 7.9 views to the site, all of that. You could repeatedly refer to the site.
Yes.
And the site, again, for these purposes, your unit of assessment is area 20 as a whole, rather than the appeal site itself, as I understand it.
Incorrect.
Okay, let's have a look. The site is defined at 7.11. To the east, are you with me? Sorry, 7.11,
yes,
thank you. To the east, the site's bordered by Steeple View, an area, existing area of residential development, right?
Yeah.
The A127 forms the southern boundary to the site, yeah?
Yeah.
With the Ford Research Development Centre located to the south. It's not, is it? But anyway, that's to the southwest. It's certainly not to the south. Anyway, and the inspector can have a look at that. Residential development to the southeast. The western end of the site. Now, where's that? The western end of the site, we're told, is bordered by an area of playing fields, beyond which is a junction with an overpass of the A127 and B148. Do you see?
Yes.
Let's just try and help the inspector with what we're actually talking about here. Would you mind just, if you keep a, don't know if you can, a tab in that or a thumb in that or whatever. Could you turn up the transport assessment at core document 1.125? I'm sure it might take some time to load.
Yeah,
let me know.
I'm having to download
PDF
it.
page 92, whenever, if anyone gets there.
Is it part 1 or part 2?
Yeah, I don't.
Transport.
Let me have a look. Mine's not in parts, which is a bit odd. It should be just core document 1.125. I don't.
Okay. What page are you on?
Is that it? It's on PDF page 92. Let's just see if you can find it. I don't know, Inspector, have you got it, or has it been subdivided into parts on the council's website? It's what it is Appendix A. So it comes immediately after the main text of the first of the document. The main text stops at paginated page 84, and then there's Appendix A, which comes after. So I don't know whether that's in part 1 or part 2.
Yeah, I think mine just jumped straight into Appendix B. I've got the location plan, but
oh, so you've not got Appendix A at all. How odd. Yeah, I've just managed to put it away. I think so. Is that Appendix A? Yeah, that sounds right. It's the local facilities plan, exactly. Any joy at all?
not on the ones I've got. So,
have you got it? Yeah, that'd be great if it could be. Thank you so much. Very grateful. It's just that it's not for any transporty purpose. This
is actually from court.
It's not quite. It doesn't go far enough. Oh dear. You've got one that, if you could, if you could just borrow it. It's just for a moment. Thank you so much. Thank you very much. Sorry. Do you want to? Yeah. Are you okay to? You can see that plan. That's the plan. Yeah. So the reason for doing this, sorry for the faff of it, we can obviously see the site. We can see immediately under the site the A127.
Yes.
The reason for doing this is because I was trying to find a map that had clear road markings on. We can see, it might take some zooming, Inspector, but you can see where the B148 is. I don't know if you can see the marking for Little Langdon, which is sort of directly down to the south of the site. Right next to that is the B148. Yeah, so there's the Little Langdon. Immediately above that, right to the south of our site, is the B148. And the reason for, again, mentioning this is that the B148 then loops, goes immediately west, if you just sort of track the B148, and then it turns north.
Yeah.
And it actually goes off our map briefly, yes. But then you'll see right at the fringe, the left-hand fringe of the site, the B148 peaks back again. And that is where the B148 meets the A127. That's where that happens. You see?
Yeah.
And immediately to the north east of that a crossing. That is where we see, we can't see it on this map, but just the inspector's clear, and she's probably picked up on driving past it. That's the football club. That's the Billericay Town Colts football club with the pitches. In the parcel of land that is, do you see where Southfield Chase is marked? Again, it might take some zooming in a bit. Southfield Chase, just next to Windermere Farm. Do you see that? Just it runs south from Dunton Road.
Yeah.
You see that?
Yeah.
So it's to the left of that, to the west of that, towards where the B148 meets the A127. It within that area, as the inspector can see when she visits, that's where all the football pitches are that are associated with the Billericay Town Colts Football Club. Does that reflect your understanding?
Yeah.
Good. All right. So thank you for that. You can put that away. So if we just go back then with all of that knowledge in our minds, we go back to your proof of evidence when you tell us what site it is that you're assessing when it comes to the visual component of greenbelt openness. We left you, if you like, on page 25. You've repeatedly referred to this unit of the site, having referred, it should be said, throughout your proof up until this point, just to area 20 and not the site. You then refer to the site, and you tell us that the western end of the site is bordered by playing fields, beyond which is a junction with the overpass for the A127 and B148.
Yeah.
So it's
the wider parcel.
Perfectly clear, even though you disagreed when I put it to you 5 minutes ago, it's perfectly clear that the site itself that you're dealing with on this page is in fact the whole thing. It's area 20 as a whole. Okie dokie. Which means, again, to just cut us a long story short, that you have not conducted an appeal site specific assessment of the visual components of openness in your proof.
Well, I have, but I take your point that it's not specifically referenced, and it's clear that that paragraph refers to the wider parcel.
Okay, if it's clear that when you're defining what the site is, you're including the wider parcel, where do you take the inspector to identify an appeal site specific analysis of the visual components of openness in your proof?
Yeah, I take your point.
Yeah, do you? So we agree then that your evidence, your proof of evidence, when it comes to greenbelt purposes, both of them that are in dispute, purpose 1 and purpose 3, when it comes to the spatial components of greenbelt openness, and when it comes to the visual components of greenbelt openness, has not at all been site specific. You have throughout given evidence, not on, if we like for shorthand, H9, not on that, on all of it. That's what you've done.
Yes.
And don't you see the problem with that? Because we've agreed right at the outset of this that we've got to be really careful, not just to assume that conclusions that are reached for area 20 as a whole can't just be sort of crowbarred into H9. Site-specific analysis is required. That's what the council did in 2018.
Yes.
You have not addressed the conclusions they reached in 2018. You've not sought to express why you agree or disagree with those conclusions until 10 minutes ago. And you have not yourself given any site-specific analysis so far as the greenbelt implications of this site go.
Yeah.
Okay. No more questions. Thank you very much.
Thank you. Just a couple of questions from me. Most of it's actually been covered already. Just turn back to the start of your proof. where you set out how you've approached the evidence writing, and it's paragraph 1.12.
Yes.
I just need to understand from you, just check it's the right paragraph. So you said you use the following published best practice guidance for considering the potential impact on the openness of the greenbelt. And the third one there is the guidelines for the LVIA assessment. In what way does that help you with assessing openness, that document?
The visual effects are a useful starting point to assessing the visual impact of the development. It helps obviously understand where views of the site are currently and where those will be mostly affected. And that then in turn helps understand the level of harm. But also conversely, even if there was no level of harm, you know, there still can be a visual harm to openness. But for me, it's a starting point looking at Mr. Chard's views and viewpoints, the ones that we've obviously gone to visit as well as part of our LVIR, identifying the receptors and where that's likely to be impacted. And then in the short, middle and long distance views, where that impact of, where that reduction of openness is mostly taking place.
So you say that that document sets out a specific approach to assessing openness in greenbelt terms.
Not in openness, but it's a starting point. So that's why
How can it be a starting point if it doesn't assess openness?
It assesses the visual impact of developments to receptors, and that's helpful in understanding where the reduction of openness is taking place from those specific viewpoints, the extent that the development will be viewed, and how that will, where the reduction of openness will be taking place.
Okay. Are you able to answer any questions on the policy side, or should I leave those for the other?
I would leave them for Keith.
Yeah, so greenbelt policy as well, he will respond on, will he?
Yes.
Yeah, okay. Uh, 4.3 of your proof.
Yeah.
I wasn't sure what you meant by the last sentence on there. So the presence of urban development within the greenbelt can increase the relationship between greenbelt and an inset settlement, and in turn diminish the contribution of the land to the greenbelt purposes. In the context of this appeal scheme, what do you actually mean by that?
So the development would diminish the separation that's currently there. There's currently a distinction between the residential part of Steeple View and the openness of the greenbelt. So that would obliterate that distinction between the two. So it would, by doing that, it diminishes that contribution, those contributions.
And you're referring to, so when you say inset settlement, where are you meaning?
Steeple View, and to the south, the Ford Centre, Research Centre, and Langdon, those two settlements. So to the east and the south.
Okay. And then the references at 7:12 to the public rights of way. I think you clarified that this was in the context of area 20 on the whole, but in terms of the public rights of way, is that still a relevant paragraph then?
It is still relevant because there is a public right of way immediately adjacent to the site, the west. Public right of way 427949.
Yeah.
And then that then continues across Dunton Road to the north. And then there's another nearby footpath to the northwest.
Okay, so but what you've said in the proof, the dominance of development in this location will be particularly apparent given the direction of travel along the public right of way network. Travelling along the public rights of way that you just highlighted.
Yes, they're north-south
Yeah.
route. So if you'll either be, I mean, it stops abruptly at the A127, that 279, the Basildon 49 footpath.
Yeah.
But if you were obviously travelling along there, you would have the development to your east, where it would obviously completely unbalance the view, where you've got that development and then the farm. And then if you were heading southwards, you would then obviously, it would be on the opposite side, travelling south.
Okay, thank you, Mr. Reynolds. Ms. Ollie?
Mr. Reynolds, you're taken to CD 8.45 at page 45. Can we go back there, please? So it's electronic page 49, but I think it's internal page 45. It's 8.45.
LVIR.
No, it's the 2018 Greenbelt topic paper. Oh, sorry. Okay. So it is. I've got too many tabs open and I'm losing the numbers. 8.2.
Yeah.
So where we've got site option, so H9 land west of Steepleview, and we went through the harm likely to arise. Do you remember that? Went through with Mr. Simons.
On page 45.
Well, yes, or
in that table,
or
yeah.
electronic 49. Yes, that's in the table.
Yeah.
So I think I'm right in saying it was put to you that it was directly contrary to your evidence, and I didn't have a clear answer to that. Is it, or do you disagree that that's directly contrary to your evidence?
What part? Sorry, although just the document being contrary.
Well, this part, what it says about H9. So H9 is what?
Where it's described in the harm likely to arise.
Yes. So it's Greenbelt sub area 20. But what is H9? You've got on the map that we prepared earlier. What does H9 equate to now?
It is.
Oh, I'm trying not to. Have you got the plan that the council prepared today?
Thank you.
Oh, sorry, I didn't realise that you didn't have it. I do apologise. It's
Yes.
and this one looks like that.
Yes. Yeah.
Okay. So H9. What does that equate to today? Where in terms of where we've got to today?
So this is a small parcel or a small part of that wider parcel or area 20. So this is obviously the eastern compartment of that wider area.
Okay. So in terms of the harm likely to arise, I mean, just want to be clear about what you say in terms of whether you agree or disagree with that harm as it was assessed there.
So the area, it's saying that I disagree that that it's not significant harm. I agree that I believe, in my opinion, there would be substantial harm to those purposes, and obviously to the openness as well.
Okay. And you're asked lots of questions about the 2017, 2018 document and 2013. Now, you said, you recall, that you didn't think that the 2013 document had any weight.
Correct.
And I don't think I'm leading. I think that was because you said that compared to more recent studies, the boundaries might have changed.
That's correct.
So
yeah, so there may or may not have been changes to the landscape, including those boundaries. So it could have been the case in 2013 that the boundaries were more robust, there was more dense vegetation. However, the situation now, as per that 2018 assessment, they've obviously concluded that there will be harm to the contribution of those purposes, or the parcel and the site contributes to those purposes.
Okay, so in terms of thinking of the relevant documents that we've got on this issue, so 2013, 17, 18, 23, which is the one that you would direct the inspector towards as having the most weight and the most use to her?
I would refer to the latest document, the latest Greenbelt review, and my own assessment as well, 2023.
So when you say your own assessment, can I be clear about which document you're?
My LVIR.
The LVIR. Okay. So does the LVIR focus on the whole parcel area 20, or is it site specific?
It is site specific. There was a review, so there's a review of the baseline evidence within that document. There is, we then go through, in terms of landscape and visual, we identify the receptors where there's likely to be harm and give an indication of that level of harm in landscape and visual terms. And then at the end, we undertake a site-specific assessment.
Okay, thank you. And I think you spoke about the A127 boundary, and you said that it emphasises the loss of openness. Do you recall that?
The A127 boundary is obviously a robust physical feature. And so that's quite a regular boundary that helps create a vast sense of separation from that land to the south and to the north. What that means is that the A127 is in itself a robust barrier, and it forms a barrier to sprawl, in addition to the green belt performing that function as well.
So in the context of this development, can you explain why you say that the loss of openness is going to be emphasised, so we can focus in on that?
The development will obviously, as kind of we've spoken about, kind of going through, the development kind of will introduce new built form, and that will in turn have an impact on the spatial aspect of it. So it's commonly accepted that spatial incursion would occur in 3 dimensions. The design, I think the committee report refers to the number of dwellings coming forward. There's bedroom, there's flats, there's houses. Some of the houses are predominantly 2-storey, and you've got flats which are up to 3-storey as well, some of which are pepper potted across the site. But all of those would obviously create a permanent built form across 2 to 3 stories, extending across that appeal site. That in itself would kind of substantially erode the openness compared to the undeveloped nature of the site. In addition, there would be a loss of openness, a loss of spatial openness from the built footprint, proposed parking, the roadways, the public footpaths, the back garden spaces, fencing, lighting, and other, associated infrastructure. Landscape mitigation coming forward, whilst, and I have accepted in my LVIR that can help reduce landscape and visual harm. What that means is that the level of harm in terms of reduction is increased, and it emphasises that there's going to be a reduction of openness in the green belt by its very nature. You've got an open site along the A127 that will then in turn become a wall, a barrier of that acoustic fence, planting, all of which is going to obviously take time to develop. That itself emphasises that reduction alongside of the built form that will be seen above that feature itself.
And you were asked in the context of urban sprawl, I think you were asked about 2 farm complexes, Steepleview and Sellers Farm. Do you remember that?
Steepleview is...
Yeah, you were asked about Steepleview and Sellers Farm. Yes. Yeah. So we're talking about urban sprawl. And I just wondered, would you call the farm buildings urban sprawl, or would you call them something different?
I wouldn't call them urban sprawl.
What would they be?
They're just their farmsteads within the rural countryside. Their boundaries are defined by a private access road. There's some intervening hedgerow boundary vegetation. They're what I would define as irregular boundary features.
So and finally, if the inspector were to conclude that she doesn't get much from your proof on H9, the appeal site specifically, what does she have from you, from the council, so that she can understand the council's case on greenbelt and openness?
So she can refer to the LVIR, that would be useful. That talks about obviously the level of harm. The proof of evidence does obviously discuss all of those points. Obviously it does refer to the wider parcel, but it does in talk about the site itself. So it does remain valid, and those points do remain valid in the conclusion. And obviously there's the existing evidence, the latest evidence.
Okay, thank you. No more questions from me, ma'am.
Yep, you need to come and sit down here. Or you got the microphone there, sorry. Yes.
So based on that, if this development went ahead, your professional opinion, do you think that?
I'm not here to obviously talk about landscape. So I have concluded that there will be adverse harm, substantial adverse harm. Correct. So I would stand by that.
And on page 9 of that report, fourth bottom paragraph, there are some characteristics. Those characteristics negatively impact.
What page, sorry?
Page 9 of your LVI.
Yeah.
Very bottom paragraph on the right hand side.
Yes. Yes. Yeah. The key. Yeah, I've got the key characteristics for this area. Yes.
But overall, based on this particular review, because it is site, you, in your professional opinion,
from landscape and visual perspective, I have concluded that there would be a substantial adverse impact.
Okay, thank you, Mr. Reynolds. So it's 3:05. If we have a break until 3:20, would you mind moving forward? Because then I know that you're wanting to partake. And we just need to have a think about start time for tomorrow. So just so I'm aware, is there always going to be somebody here from the Rule 6 for the whole inquiry?
That is the plan. We're trying to
Right.
coordinate because it's obviously
Yeah.
other residents.
Okay.
It won't be us two here tomorrow. There will be 2 people here tomorrow.
Okay, so we need to agree with finishing slightly earlier tomorrow because I have a commitment, unfortunately. But so we were planning, I think, to start slightly earlier tomorrow and have a shorter lunch break. So could people just have a think about what time they're content with in terms of early?
Could I just, on that topic then, Madam, we could obviously have a chat in the break, but just if we're about to do Mr. Hargest in chief, I think, which is the plan. And I suspect, given that Ms. Ollie indicated slightly longer evidence in chief for Mr. Hargest, we might find that we get to the end of that, and I don't know, we'll probably stop rather than start some. So if that were to be the approach, we're running quite significantly ahead of ourselves, aren't we? Because we've got all day tomorrow for the on the timetable for the LPA case, but of course we're going to be ahead of that. So I wondered whether something like 9:30. I mean, I wondered, but 9:30 would be, I think, would give us more than enough time to both finish Mr. Hargest and actually potentially, even I don't know if the Rule 6 parties be ready, but to move on to their case as well. I'm
very happy either way with the start time.
I'll touch base and we'll come back to you.
With regards to the Rule 6, we've got it scheduled in for Thursday, and people that are attending on Thursday can.
Okay.
It might have a gap then. I don't think Mr. Hargest would take all of them.
It'd probably be done in the morning. Your call, man, we could then just stop, or what we could do.
Would be very lazy and stuff.
We could do that too, Madam. We could do that too. If you prefer, Madam, we could actually pause. We could pause now and do Mr. Hargest tomorrow. So that he's all done it, if you like, on the same day, if you prefer, rather than him being broken overnight.
Sorry, the timetable isn't. It flows as it flows. So but when there's a session indicated, if we're running ahead, we would be looking to bring that forward. Okay.
I can't commit.
Well, could you find out, Mr. Dad's indicated this morning it would be if it's a 15 minutes. I think he indicated this morning. I've got written down. In terms of
the evidence in chief.
Yeah, the statement reading. So, okay.
I mean, in that case, we might be able to work around it anyway, Madam, by bringing forward maybe our Greenbelt case in advance, say, or something like that.
Okay.
So,
well, have a chat amongst yourselves about what time you would like to start tomorrow.
You'd like to presumably press on with Mr. Hargest this afternoon?
I would, yeah.
Okay.
Yeah. Okay. So we'll adjourn until 3:30 then, to give you the full 20 minutes now. Okay. So the inquiry's adjourned. Thank you. Okay, it's 3:30, so the inquiry's resumed. I've got a local resident has approached me about some photographs. I don't know, you've got them there, okay. Could you just explain what, for the benefit of everybody, what they are, and then we'll see the views of the parties. Mr. Simons, could you, yeah,
No objection.
any views from the council? No, okay, have you got copies for everybody?
No.
No.
Okay.
If perhaps they could, if it could be copied for everyone, sort of thing, then we've got no objection to it all being handed in.
Okay, that's okay.
It's too personal, that you can accommodate that she can then answer any questions. Then she wouldn't be able to think, so someone else may have.
As I said earlier, we might, if it helps, we would be happy if it's a shortish period, which I think is what Mr. Dad's indicated earlier, to sort of interpose the Rule 6 case into the middle of our evidence. So, for example, after Mr. Hargest has finished tomorrow, we could go straight to Mr. Chard, for example, get to see where we get to tomorrow, and then, you know, still interpose the Rule 6 party on Thursday morning, sort of thing. If that works for everyone, that would obviously allow them to speak.
Yes, that works. That works for me. So we'll probably proceed on that basis then. So and in terms of start time tomorrow, what is everybody?
I think we settled on, well, I said we settled, we discussed 9:30.
9:30, okay. So we will have a shorter morning and lunch break then, because I do have to finish unfortunately at 3. So that will be tomorrow. Okay.
So I've lost my core documents, so I'm just waiting for it to come back.
That's fine. When you do get it, are you able to give me the list as well? If they're...
Well, what I'm going to do, ma'am, is I'm not going to go through Mr. Hodges' proof that you've read that, so to save time, I'm just going to answer his comments on other people's evidence.
Okay.
Essentially, Mr. Child's daughter, Mr. Fisher's two appendices, Mr. Fisher. And I'm just trying to open because that's the first place I wanted to go to.
Is it possible to leave any documents here overnight? Before I forget, I need the pass as well, so I can, because they've only given me a day pass. Somebody was going to sort that out for a week one. Yeah.
So good afternoon, Mr. Hargest. I've just said I'm not going to go through the points in your proof, but I'll introduce you. You've been instructed by the council to appear as an independent planning witness, obviously, in relation to this appeal, and you're a consultant member of Fuller Long Limited, a cooperative of planning consultants with in London and elsewhere, director of your own planning consultancy, Hargest Planning Limited, and the precursor to that for the last 20 years, so since 2003. And you have held positions in planning consultancies in both Scotland And England, you provide planning advice to a wide range of clients, public and private sector. And you've got over 30 years professional planning experience, member of the RTPI, member of the RICS, and also the Chartered Institution of Highways and Transportation, Master of Philosophy degree in Town Planning from Newcastle, and a Master of Arts degree from Cambridge. So you're very well qualified. Okay, so without further ado, I know that you've got some comments on the evidence put in by others. So if we could start with Mr. Chard's evidence. So if we could open his proof, and I'd like to take you to paragraph 2.16 onwards. So this is dealing with the housing options topic paper 2018. So with the appeal site identified as site H9 option A. And that is, as he says, CD 8.13, if you want to have that there for reference. But what do you say about this section of Mr. Chard's proof, please?
Sorry, I just have to get straight myself. I'm not quite sure where we're going.
Okay. So just give you a moment to get Mr. Chard's proof and the topic paper from 2018 that he's talking about, paragraphs 216 through 220.
Yes, I think many of these points have been covered in the examination of Mr. Reynolds, in that, yes, there are various comments about the housing options topic paper, CD 813, but I think that he's relatively selective in the comments. So there are quite a few negative comments about site H9, which is the appeal site, of course. So, for example, on page 74 of CD 813, I mean, I would question there. I'm not quite sure how the paper sees development of the site assisting town centre regeneration. So I've got CD 813,
8.13,
which is it's the housing options topic paper. Yeah. So I think to a degree this is overlapping with some of the evidence just earlier this afternoon. So there are the various comments, for example, page 75 of CD 813. So it identifies the site as having a relatively low landscape capacity rating, which is the second worst category in that document. So that's on CD 813, page 8. You see that the reference to the categories of landscape, I suppose, categorization. There's reference to the location of the site being in walking distance of the nearest primary school. Well, that's addressed in our statement of common ground and the distances, the nearest being Millhouse Infant School. So I think just generally, I think that there are some selective comments in there that the document needs to be read as a whole, and the site appraisal needs to be assessed as a whole.
Paragraph 3.20, paragraph 3.26. He's talking about the outline landscape appraisals 2017.
Yes, I mean, if we look at, so that's the CD 814 or 816. I've got two references for that. Why it's, I'm not sure why it's got two core document numbers.
says at the end of paragraph 3.26, do you have the proof?
Yeah, I'll have a look at this.
Yeah, so the last sentence says it has the potential for residential development without significant adverse landscape and visual effects as demonstrated.
I wasn't quite expecting some of these questions on these topics. I wasn't quite ready for them.
Oh, I'm sorry.
Yeah. So can you just give me the reference again? I've now got my papers confused. So Mr.
Yeah,
Child's
so
reference page is
so
his
for,
paragraph
3.26.
3.26.
That was site 16. Let's consider the development would have wider landscape and visual impacts. Would you have any comment on that?
Well, I mean, it's. I think really the key point there is the evidence that's just gone before in terms of the intervisibility between the site. The document does refer to the visibility of the site with a wide area to north. I think really I would have to defer to the evidence of Mr. Reynolds in that respect as the landscape architect and giving evidence on that topic. But I think the point being is that there are negative comments in these documents that are just not being reported in Mr. Child's evidence.
Okay. Do you have anything else you want to say in support of that point, or have we covered it?
I think it's been covered in some depth earlier.
Okay, and I appreciate this is not your area as such. You're just using it in the planning balance. Let's go to Mr. Wharton and his proof of evidence, please. So. So if we can sort of grasp this particular thorn, he's referring there quite rightly to paragraph 8 to the committee report saying that the reason for refusal on the grounds that the site's within an unsustainable location could not be sustained. So obviously we're putting a different case forward. So could you summarise your approach to that, please?
I think really the issue about sustainability in my approach is focusing purely on transport sustainability, since that's the only factor referred to in the reason for refusal 3, is that in terms of walking, I do not consider the site as easily accessible in terms of access to facilities and services. In terms of cycling, I consider it's got reasonable accessibility. I don't think it's excellent as Mr. Wharton suggests. I think it is. It's okay. It's very typical for a kind of an urban location. In terms of bus and public transport, existing accessibility is very poor in my view. And on that basis, I would consider that should the appeal be upheld, it's absolutely essential that there is a significant, substantial improvement in public transport accessibility. We can come on, further comment on that further later on. And obviously, in terms of rail, it's not accessible without having to use a car to get access to Basildon railway station and Langdon railway station rather. So the accessibility to me in sustainable transport terms is particularly deficient in terms of walking and in public transport.
So in terms of the mitigation that's proposed in relation to walking, just focusing on that, what's your view?
Well, the proposals are, they provide links from the site. They provide a footpath along the south side of Dunton Road, and therefore link to the existing footpath along Dunton Road, and also provide footpaths links to the southeast corner of the site, which would provide access, direct access to the combined pedestrian and cycleway alongside the A127. That's all that is proposed. I haven't had an opportunity to see the up-to-date version of the Section 106. I know there was talk about some cycleway improvements on High Road, but I'm not sure whether they're actually in that Section 106 at the moment. That would need to be confirmed. But as far as walking accessibility, even though there are links from the site to the adjoining pedestrian network, it doesn't make the site any more accessible. It doesn't bring the facilities and services closer to the site. It can't do that. It's impossible. So the fundamental problem about the distance and the journey time walking to get access to facilities remains the same. Yes, in fact, if the link to the southeast hadn't been provided, it would be even worse. But you know, I've done my assessment on the basis that link is provided, and to me, even with that link, it is still it's not easily accessible to a range of services and facilities. And as far as the public transport is concerned, as I say in my evidence, I've got particular concerns about, I recognise that the financial contribution is now included in the section 106 proposed agreement, and that this would be used by the county council to pump prime. I believe what it's talked about is an hourly service. And in the statement of common ground between the appellants and the county council, it talks in terms of it being a 5-year period as pump priming. Problems I have are that I accept now that there is that the appellants are indicating a commitment to provide that financial service. And I didn't do that in my proof because it wasn't available at the time. What I don't see is any indication or even tentative support from an operator that actually provide such service, even with that financial subsidy. So I've got a question mark there. We don't have details of what the service would be, how frequent, where it would access. Though again, I do see that there is a plan provided in the statement of common ground between the appellants and the county council as about a proposed route. But I'm still not sure, if this bus service doesn't prove viable, after 5 years it would be withdrawn, assuming, of course, that there is an operator to take it up in the first place, which means that there is a risk that this development could involve 269 houses without a regular bus service. So, I mean, I would definitely welcome the financial contribution, but there are still grave doubts about the quality of the service and the fact whether the service would actually exist in the long term. Now that is a concern for this site because it's so badly served at the moment.
So, sorry, it sounded like you started a sentence then, because this site is so badly.
Oh no, it's because I do think it's critical that there needs to be a regular bus service. So we're talking about hourly, running at least 6 days of the week, and I would strongly prefer 7 days a week, linking clearly to the town centre, to Langdon, to the principal destinations, and I would see that as Billericay. So I think the proposed route in the statement of common ground would seem reasonable to me. But my real concern is that 5 years isn't the duration of this development. 5 years is just the pump priming exercise. And if for one reason or another that service isn't continued, we are then left with in perpetuity a development of 269 houses without access to a regular bus service within easy walking distance. That is a concern to me.
Just perhaps focusing on walking. Mr. Wharton, I think, if it's not, well, I'll put it a different way. Mr. Wharton has referred to the applicability of the qualification for school transport. He's factored that in when we're talking about walking distances. Do you think that is a useful guide, or is that useful? Is it relevant?
This would be a reference, I believe, if I got it correctly, to Mr. Wharton's Appendix D.
Yes, IWD. Yes.
So that's the travel school for children. I'll read upside down. Travel to school for children of compulsory school age. So that's attached to his proof rather than a core document. And he seems to be placing weight in his proof on the fact that uses the 2 mile threshold as the basis from which there will be really the county council will take responsibility for paying effectively for the transport of children to and from school. That to me, I mean, just reading what the reference in there. So this is paragraph 9 in that appendix. So it says the statutory walking distances are used to determine whether a child is eligible for free travel to school. It's not a statement of whether that's a reasonable walking distance or not. And it goes on, there are the distance beyond which a child who is attending their nearest suitable school is eligible for free travel arranged by their local authority. So, where a child lives within the statutory walking distance, which in this case is 2 miles, and is not eligible for free travel or any other grounds set out in this guidance, the parent is responsible for arranging the child's travel to school. But there is no expectation that the child will walk. So there's no inference at all from this document that 2 miles is an appropriate walking distance in any form for school children. And indeed, I would suggest that that proposition that it is a reasonable walking distance is absurd, because it could allow for the situation where you've got a 7-year-old walking to primary school 1.99 miles in the morning and in the afternoon just to get access to school as a reasonable walking distance. That is clearly not the inference here.
And what about the role of the overbridge in this case, and how that's going to interplay with whether people would choose to walk?
Well, I do know Mr. Wharton seems to appear to think that using the overbridge is perfectly acceptable as a route. I don't think if you are a healthy adult or youth, using that overbridge is fine. But the fact is, it's a stamped S. It has got steps and ramps. So if you can't access that, you can't use that overbridge if you are dependent on, for example, if you're disabled and in a wheelchair, it's impossible. And on the way down, it'd be extremely dangerous, I think, with the bumps going through. So it's not an easily accessible route. Sorry, I should qualify that. It's not an easily accessible route for all members of the community.
I think you've said probably what you need to say about the bus improvements, and I note that you don't say anything in particular about cycling. You just say that yes, it's not excellent, but it's.
I would say it's normal.
It's
the route, the cycling routes in the area around comprise use of ordinary roads, and there are some combined pedestrian cycle routes off-road in the Steeple View area in general. I cycle a lot. I'm actually a commuter to work, so I'm quite experienced as a cyclist. I wouldn't use them because there are two major drawbacks with their design, and it's a design that's common throughout the UK. Is that if you're on one of these cycle routes off-road, you then have to give way to every side road, which to me as a cyclist is a major disincentive. And there are also issues, I think some pedestrians can take some concern about the idea of sharing a space with cyclists, especially if they're a bit too fast. So there can be an amenity issue as well. But I don't think they are particularly, I don't think they're particularly problematic. I just think it's just the nature of the design that has been prevalent throughout the UK. It's often not, it's not treating cyclists as a mode of transport. It's more seeing it as a recreation activity. And I think that's a major problem with the highways and transport industry as a whole. But I'll still come back to the point. I think cycling access in the area around is quite adequate and it's quite normal.
Is there a sort of hierarchy, between walking and cycling? I mean, is one more important than the other? Are they both important?
Well, yes, there is. For example, Essex County Council does have a road user hierarchy. Top of the hierarchy is walking, second is cycling, third is public transport, and then private motorised transport below that. And it states, the first preference is support pedestrians, and then the second choice is cyclists. So it's supporting active travel. The most important one is being walking. And you need to place that in the context of how often do people walk compared to cycle. And here I'm quite atypical in that I probably cycle as much as I walk. Most people don't. There's quite a lot of variation in what the stats tell us about the relative importance of walking compared to cycling. But just by one example, we could refer back to Mr. Wharton's transport assessment, which kind of gives the minimum comparison. Now so this is document CD11225. It's table 5.2, page 46. This is where he talks about the trip distribution in peak hour. And of course, bear in mind, this is peak hour because it's a transport assessment. It's not concerned with overall use of different travel modes. And this identifies in the peak hour, it identifies 1.2% of trips would be cycling, but walking would be 3.5%. So basically, even in that assessment, it's assumed that there's going to be approximately 3 times as many walking trips to and from the development at peak hour than there will be cycling trips. But in fact, if we look at the cycling statistics for England and Wales, the most recent ones of 2022, this shows actually the comparative importance of walking compared to cycling is far greater than that. It measures journeys either as trips or as stages. A trip being a whole journey, a stage being a significant part of change, but then there's a shift in modal, a form of transport mode, typically associated with, say, buying a ticket. So there are more stages than there are trips. But just from its statistics, so for the most recent year, 2022, for walking, there were 260, the average person averaged 267 trips and 318 stages walking. And on average, they spent 90 minutes per week. Now, this is a survey, so it's going to be subject to some variation, but it gives you an idea. But when you look at cycling, the average is 15 trips and 16 stages and 7 minutes per week. So immediately, from those statistics, you can get up to walking being up to 20 times more important to the average person than cycling. So whereas I think that cycling is adequate and accessibility, walking is far, far more important. And furthermore, out of those trips, bear in mind that we're talking here about access to services and facilities. A higher proportion of cycling trips are purely for leisure purposes. The survey identified 54%. Whereas we're talking about access to school, access to shops and other facilities, the proportion of leisure walking is significantly smaller, it's 29%. So that even increases further the importance of walking compared to cycling for accessing services and facilities. Yeah.
Proposed to give to the new residents. In your global experience, are they useful?
I think they're useful and they should be provided. I think that's important that they're provided. But they don't seem to, so far, there doesn't seem to be any major impact. I mean, I haven't seen any assessment of whether they make any real difference. Do they increase walking? I think their biggest use is informing about bus routes, honestly, when people first arrive. And that comes back to my point earlier about the importance of having a regular bus service and whether it's permanent.
Let's move to Mr. Fisher. Sorry. Okay, so in his section 3, he's talking about the Basildon saved policies. That starts on page 11 or electronic page 14. If we go to 3.2.7, then we get to consideration of BAS GB1, which is the definition of the green belt, if you're with me. So that's electronic page 16 or page 13 on the hard copy. What do you say about that policy, please? So I've got your answer clearly.
Well, and again, I think actually this has been touched a little bit on Mr. Reynolds' cross-examination. Obviously, the Greenbelt policy is, no, sorry, I apologize. It's in the opening address about the age of the Greenbelt policy. If we look at, well, I suppose the first thing is to say that in 2018, there was a review undertaken of the SAFE policies and whether they are in accordance or not with national planning policy. And the conclusion as far as the Greenbelt is concerned is that it was, you know, it is in accordance with the national policy. So as a policy principle, you know, it is up to date. It raises the issue then about the area which can be disputed is about, and directly relevant to this appeal, it's about the boundary of the Greenbelt and the inner boundary of the Greenbelt. And the fact that these have not really been reviewed since 1998. There was a review clearly that was proposed as we came up to the proposed local plan and the identification of sites, but this clearly was withdrawn. I wasn't involved in the council at that stage. I cannot offer any reasons for that withdrawal. But the fact is that, you know, the advice in MPPF is that Greenbelt should only be reviewed in appropriate exceptional circumstances, and that this should be undertaken through the development plan process. Rightly or wrongly, the council has not gone through the review of the development plan process. So there hasn't been a mechanism by which they could review Greenbelt boundaries as the correct way of doing it. And I would suggest that given the importance attached to Greenbelt boundaries in the MPPF, the right way of doing this is through development planning and not through planning by appeal. It's an unfortunate situation, and you know, I can see that the council should be criticised for not having, you know, grasped the nettle of reviewing the Greenbelt, but there hasn't been the mechanism. So we are left with the Greenbelt as it is.
I was going to ask you about 3.2.8, but I think you've covered that then, haven't you? Yeah, okay. Your response to 3.2.9, if you would.
Yes, in this paragraph, Mr. Fisher says that there are no clear instructions what can and cannot happen within the Greenbelt. Given that it's very clear what the MPPF says in paragraph 11, as to, and the footnote that goes with it, that when we're dealing with a situation where we haven't got an up-to-date local plan, but we do have a defined Greenbelt, that the policies set out in MPPF and the paragraphs that are relevant to that in effect take precedence. They need to be followed, and it is very clear in that section of the MPPF what is and what is not acceptable as development within the Greenbelt. So I don't really understand how we can take the view that there are no clear instructions about what can and cannot be developed. To me, the MPPF is completely clear.
And then let's look at BAS BE 12. So I think that's 3.2.11, yes. Section 3.2.11. 3.2.16. So I mean, do you agree or disagree that the development complies with?
Sorry, could you give me a core document number for that?
Oh, I'm sorry, I'm still in Mr. Fisher's proof.
No, it's 4.3.
Yeah, I'm just in Mr. Fisher's proof and his treatment of BE 12.
Oh right, you know what? Sorry, I apologise. I'm going to comment on Mr. Chard's comments on 3.2. Mr. Fisher, sorry. I'm getting completely confused now.
So he says
Yes,
it complies.
yes.
Do you agree?
Yeah, I disagree in that policy B12, I would consider is, well, if I read the actual policy, which is probably useful. So that's on page 51 of CD 4.3. The first criteria, so I mean, the policy says planning permission for new, so this is policy BSB 12, planning permission for new residential development and for the alteration and extension of existing dwellings will be refused if it causes material harm to any of the following, in any of the following ways. First one is harm to the character of the surrounding area, including the street scene. I would interpret that the surrounding area includes greenbelt. So if there is a clear harm to the greenbelt, that would come under criterion I. He accepts that, you know, there's no disagreement between us that there are localized impacts at the very least. There is disagreement about the wider impacts on the greenbelt. But the very fact is that there's an adverse localized impact on the greenbelt means that, to me, that you're clearly in breach of policy BSB 12.
Mr. Fisher's proof, where he deals at harm, loss of agricultural land, 4.4.25. So that's electronic page 23, internal page 20, Mr. Fisher. You haven't dealt with impact on agricultural land in your proof. Is there a reason for that?
The reason is probably incompetence on my part, in that I was reducing the length of my proof and managed to cut it out. And since, you know, I have to accept the fact that I have not included it in my proof. I do not, my view about impact on agricultural land would be the same as is set out in the committee reports at CD 3.1, which is para 5.16.1. And note there that the officers placed moderate weight regarding the loss of agricultural land. And equally, I should say that I have no dispute with the agricultural land loss as set out in the agricultural land classification submitted by the appellants as part of the application. That's CD 1.103, that's table 2. I have no reason at all to dispute the figures that are in there. But just by way of summary, it just identifies that out of the 9.3 hectares, 6.2 hectares is grade 3A, which is good quality agricultural land.
The next point is 4.4.53. In relation to biodiversity net gain. I understand that you're not sure about the calculation there, so could you explain to us?
Yeah, I think there's a relatively minor arithmetical error in the calculations of BNG in that document. So that's document CD 1.115. In the executive summary, it states that the area habitats existing 21.95 units, proposed 24.52 units. So that's a net increase of 11.7%, call that 12%. The linear habitats existing 7.54 units, proposes 11.76 units. The summary identifies it as plus 78.7%. Well, arithmetically, that's wrong. It should actually be plus 56%. But I don't dispute the fact that the proposal does create biodiversity net gain.
Okay. Paragraph 4.4.57, page 29 or page 26, hard copy.
Yes,
This is,
let me just get
yeah, I
the,
just wanted to ask really what you get from the fact that they say that the site has a level of accessibility very close to the threshold for a good rating. So should it be regarded as good, or what do you make of that?
it may be close to the threshold, but it is still been assessed by the consultants for the council as limited accessibility. It is not good. It's also quite it is notable that if you look at the sites that they assessed, there are 24 sites. This site was ranked 20th out of them in terms of the score. I mean, putting aside the method, they used a certain methodology and they came out with that answer. But the fact is, it is below the threshold for good accessibility.
And another nettle to grasp. I think I got my metaphors mixed up last time. The point being made, and it's 4.4.61 for the reference, that there's no reference to the sustainable transport section of the NPPF. What do you make of that, Mr.
Well,
Hodges?
that is correct. There is no reference to that section in the reason for refusal. There are references to paragraphs 11, 126 and 130. These do include references to supporting sustainable accessibility for sites.
Point 4.64. So it's the bottom of page 27 or electronic page 30. You yourself refer quite a lot to the Essex design guide. So do you have any comment on what's been said here?
Well, yes, I mean, I include the relevant reference. I noticed a slight difference in wording between the version that was lodged by the appellants as a core document and from that which is on the current web page for the design guide. But it does state, as I set out in my appendix, just get the correct one before it's, so this is my appendix A, and this is criteria for all development sites. That it's very clear that if we look at under the heading of proximity, where it states locating dwellings in close proximity to facilities and public transport encourages walking and cycling instead of car use for local trips. Facilities such as shops, employment and schools should be clustered together on routes. Well, that's not so relevant because we're not actually providing those. And then in addition, so this is on the next page, so it's my page 2 of 3 in Appendix A, no part of residential area should be further than or farther than 400 meters from a regular bus route. That can be addressed in part by this proposal. Parts of the site, if a regular bus route is provided in perpetuity, parts of the site would be within 400 meters. 600 meters from a primary school, well, clearly this site is not by any stretch of the imagination. It's about double the distance from the nearest one. And 1500 meters from a secondary school, again, it doesn't meet those criteria. So clearly in the criteria of the Essex Design Guide, this site does not meet those standards.
Obviously, we're not taking a point about the design of the development as a whole. Okay.
Yeah, and I'm purely taking it in terms of proximity.
And just so we've got your view on open space. So that's 4.4.71 to 74. What do you say about that relevant to the planning balance?
Yeah, I have a general problem. Open space is an example of the problem, as whether this should be treated as a positive benefit of the scheme, whether it's neutral or whether it's a disbenefit, and that comes into the planning balance issue. In this section, Mr. Fisher is trying to place emphasis on the fact that public open spaces providers and locally equipped area for play. But there is an issue. If you provide something that meets the needs of the development, I would say that that's neutral. If you provide a facility or service that goes beyond the needs of the development and serves the wider area, so it's a greater community benefit, then that's a benefit. And clearly, if you don't meet a standard, that's a disbenefit of the benefit. So I mean, take an extreme example. If you say, if you don't provide sewage, you don't meet basic standards. And clearly that counts against the development proposal. But I mean, because it's so obvious. And I think in a way, provision of open space comes with the same. I would see here that we've got open space that meets the needs of the development. That's good in its own terms. I don't think it, because of its location, I don't consider that because it's quite difficult, a significant distance to walk to, it is serving the needs of the wider community. So I would say, as far as planning balance is concerned, it's neutral. It meets standards, but it doesn't go beyond that. It meets the requirements of development.
Want to say anything about the fact that it won't be a gas development?
Well, the gas development, again, it should be welcomed in its own terms. But we do have to see that we've got the future home standard, or future homes and building standards now called, coming into effect in 2025. So this is slightly in advance of it. And therefore, I welcome it, but I only place limited weight on it. And in my proof, I say a similar sort of comment in relation to the biodiversity net gain, which is coming forward sooner. It's meant, the latest government pronouncements are that it's still going to come through in early next year. So we're only slightly ahead of the timetable. But I would still reiterate the point that these are, they are positive benefits of the scheme, just of limited weight.
Thinking about the draft local plan, obviously it was withdrawn. What conclusions can we draw, if any, about whether the council thinks that greenbelt releases are required?
I think at this stage it's difficult to draw much weight from it, because it's going, the planning authority is going through the process again of preparing for a new local plan. And that's been, the timetable of that has been highlighted earlier this morning. We don't, at the moment, well, I certainly do not know what sites are coming through the consultation process as available. We do have the HELA from 2020 and 2021. And we also do have the, make sure I get the correct term, because there's lots of different names. Yeah, it's the Greenbelt topic paper, CD 8.2. Now that topic paper, just by way of context, identified initially almost 6,900 homes, sites for homes outside the Greenbelt, and then it was adjusted to 9,098 homes on page 29. We don't have equivalent figures now because that process hasn't been, to my knowledge, has not been completed. What we do have is the HELA from 2020, and we have the additional numbers of houses from HELA 2020-2021, the addendum. In total, the sites there identify, the schedules there identify accommodation for just shy of 30,000 units. But what's quite important there is that, well, what we cannot tell from that is which sites are within and which are without the greenbelt. I say can't tell. I haven't done an analysis that identifies what proportion are greenbelt and what are not. I think if you looked at all the sites, yes, you could work it out. But it's quite important that the HELA doesn't exclude sites on the basis of greenbelt location. It doesn't say, it identifies all sites. It doesn't say that they're unsuitable. And it expressly says that it does not say that they're unsuitable. So it's included greenbelt sites. as part of the the trawl of sites. What it actually says is that where a site is within the greenbelt and within settlement proximity criteria, then it's included in the list. So what it seems to have done is excluded sites that are remote in relative terms from urban areas and are located in the greenbelt. So basically, I don't think we really can tell. It doesn't take us very far forward. And we have to leave that to the local planning process.
Thank you. And then let's just look at the two appendices. I know the first one is, of course, on something we don't want to particularly go into, housing land supply, because it's been agreed. But do you have any comments on that nonetheless? Oh, to Mr. Fisher. Yeah, sorry.
Appendix A.
Appendices A and B. I just want to briefly
Appendix A, yeah.
go through.
Well, A is housing sites, B is the economic assessment. My reading of this document is that all they have done, all that has been done by Emery Planning is they reviewed the sites in the 5-year housing land supply. So that's document CD 821. And then criticised sites have been included and said that they're not available. Now, the first thing I should say is that the assessment of housing land supply and the 5-year assessment of the 5-year housing land supply is a relatively complex process. It's not undertaken lightly, because first you've got to identify all the sites are included in existing housing land supply and identify how much have they been built out, what's their remaining capacity. That's the first thing. You've also got to look at other sites that previously were beyond the 5 years, but are now coming forward. So they need to be included. You then also got to include new consents that have taken place in the last 6 months. None of this has been done. All that has been done here is that a review of sites has been undertaken. And it appears from what's there, certainly from the comments in there, that they've tried to say, oh, well, certain factors now occur that means the capacity is reduced. Well, the only valid way of doing that exercise is to challenge what was done as per the 1st of April, which is the date of that assessment. That is the only valid way of doing it. And if you go through these sites, I would reject all of them bar one, all of the criticisms bar one. And I can go through, I think it's important to go through them quickly, because Mr. Fisher does make emphasis, oh, it's not 1.85 years land supply, which I should stress is a very poor land supply, an extremely poor land supply. And I would not shirk from that at all. But it's not less than that. Firstly, for example, he talks about Market Square. Well, Emery Planning have no involvement in that project.
Just a bit sorry to interrupt. Obviously, I'll let them give the answer, but I was hoping that we wouldn't go. I mean, I've not got Emery Planning here to actually give any evidence on any of this. And the reason for that, I'll just explain, is because the parties had agreed until now that we were all content for you to determine the appeal on the basis of what is an agreed range, so 1.85 to 1.46. And so the reason I'm intervening is because if we're to start getting into orally site by site deliverability, it's a bit of a different ball game, and we've not prepared anything on the basis that that would be the case because of the position as agreed in the statement of common ground. I don't think, given the differences, is less than half a year, even on the full extent of dispute on supply is less than half a year, and the council's best case is 1.85 years. I have doubts about the extent to which it's really worth going through site by site orally. But obviously it's a matter for you, madam.
I mean, that wasn't really the intention, but I mean, it has been put in, it's not been withdrawn, and we don't accept it's less than 1.85 for the purposes of this appeal. So I feel bound to get
you're not moving away from the position that's in the statement of common ground.
No, I just wanted his comments because it's there, and so it's been put in nonetheless, and it hasn't been withdrawn. So if it's not necessary, then I'm grateful, and we don't need to
well, I'm questioning why it's necessary if you've got an agreed position in the statements of common ground.
Well, if it's confirmed that there's not going to be any evidence led on that on the other side, then I think it cancels each other out.
Here, and we've agreed for the purposes of this appeal, that there's no more than, as it's put at 2.6.3 of the Statement of Common Ground, 1.85 years. And as you know, there's a range of figures which are there, but it's common ground that that is the upper limit on the basis of that. And I'd accept the council think it is 1.85 years. It's absolutely fine. Of course they do. But as to whether or not it's worth us actually delving into that dispute orally, you know, using inquiry time over it, as I say, I've got my doubts that to do that properly is going to take quite a lot of time for negligible benefit for any party.
Well, as I said, let's not assume that it was going to take that much time, because that wasn't the intention. But I'm going to leave in the points that Mr. Hardis makes about what one would need to do, but we don't need to go through the individual sites. I'm certainly content with that.
Okay, sorry, what would one would need to do?
He made the point about what you would have to do in order to unpick.
Yes, I've noted that. Yeah.
I'll keep that.
Yeah,
in.
but I've certainly prepared on the basis of what's in the Statements of Common Ground is the agreed position.
Grateful for that. In that case, and Mr. Hardis, if it was simply to go through those points, can we turn to the second appendix, Appendix B, Economic Benefit Statement? Because I do want to just take your comments on that, please. Then we'll get to a close of your.
Yeah, well, again, my comments on this are clearly in my statement, in the statement of case, and in my proof, I stated that there was no economic assessment provided. This has now appeared, a document has appeared anyway, purporting to be an economic statement as Appendix B. And I have a number of criticisms that would really question, would cast very severe doubt as to the validity of the findings of that economic assessment. I suppose the question is, do you want me to go through what those criticisms are? Because some of them are relatively detailed, and I realise that Mr. Fisher hasn't prepared this document, and there isn't a witness providing the economic evidence. But in general terms, I undertake economic assessments of operational development regularly, 2 or 3 times a year. So I'm quite used to undertaking this type of assessment.
I'd like to hear Mr. Hardis's view, but again, ma'am, if you don't think it's very helpful, then we won't take time.
I don't think it's, well, my question would be, what if you were so well versed in them and it wasn't part of the application, why didn't you do a supplementary proof on it?
I suppose I was being encouraged not to provide a supplementary, just to keep things focused on the reasons for reviews.
Yeah, but we need to focus in the inquiry time as well,
yeah.
Which is and bringing it up as an issue when we're in the inquiry, when the other party hasn't had a chance to respond, it is not that helpful. So it's not helpful from my perspective, no.
All right, let's revisit the planning balance, Mr. Hardis, and you've heard these are the green belts evidence today. What do you say about the planning balance?
Well, clearly based on what's in my proof, my view is that the planning balance, the weights are relatively, my wording is finely balanced. And on that basis, I consider that the relevant planning test in the MPPF is not met. In examination of Mr. Reynolds, and in my proof, I place my weight on the evidence of Mr. Reynolds in terms of identifying wider impacts on the greenbelt beyond just localized impacts. But I was aware in cross-examination, Mr. Reynolds accepted the fact that in his proof, he hadn't assessed, he really effectively been assessing the wider area rather than the specific application site, the appeal site. In re-examination, my understanding was that Mr. Reynolds was quite clear that there would be a substantial impact on greenbelt openness from this development. But I haven't got detailed notes of that. So on the basis that that is the conclusion in Mr. Reynolds, and I would defer to his evidence on that matter, I would still consider the issues are finely balanced, and that therefore the NPPF planning test is not met. If it's a misrecollection, and that Mr. Reynolds' evidence, or the conclusion is that the impact is localized, clearly that affects my assessment of planning balance, and it has to, because the adverse impacts, though substantial weight still has to be placed on impacts on the greenbelt, the magnitude of those impacts are obviously less. And on that basis, that shifts, in my view, shifts the balance towards approval of the scheme. But it does depend. That's not how I recall Mr. Reynolds' evidence. But as I say, I didn't do notes. And I think it's only fair that I say that, because it would be wrong for me not to, quite honestly, that the balance has to shift. Whether it's clear cut, I'm really not sure at the moment, and I have to think further because it's all relatively new to mull over. Because the policy, NPPF is very clear what the policy test is, and I think it's worth reminding ourselves of that. So it's 820, isn't it? I used to think paper was quicker than electronic, and sometimes it is, and sometimes it isn't. Yeah, thank you. Yeah. So, I mean, this is obviously it's paragraph 148, and I'm sure we'll return to this. So, very special circumstances. So, when considering any planning application, local planning authorities should ensure that substantial weight is given to any harm to the greenbelt. I don't think there's any dispute between parties that there is harm to the greenbelt, and clearly the CD 3.2, the committee report, stated it very clearly that the view of the officers was that it's local harm. Very special, and it goes on, very special circumstances will not exist unless the potential harm to the greenbelt by reason of inappropriateness, which this is, and any other harm resulting from the proposal is clearly outweighed by other considerations. Clearly, to me, clearly is the critical word here. And as I say, based on my recollection, it's balanced and that policy test is not met. If it's a misrecollection in the sense of, because there were a number of comments made in both directions, and that there is doubt as to whether there's a wider adverse impact, then I would say the balance of shift is in favour of the approval, but whether it clearly is difficult, because we've got certain factors here that are clearly contrary. It's not just about adverse impact on the greenbelt. In my view, the sustainable access to the site is very poor, both in terms of walking, as I've said, and my concern, the fact that there wouldn't necessarily be long-term public transport, regular public transport access. We also have a negative impact on agriculture, though I readily admit it's not in my proof, and I omitted that. And I've said that, explained that already. What we have in favour is clearly there is a substantial shortfall in housing provision and affordable housing. I place substantial weight on that, and that has to be acknowledged. I think the other matters, whether it's environmental and economic, I would place limited weight. I think the economic benefits are very limited. In terms of the context of the construction employment, that will add less than about 0.1% to the GDP of Basildon Borough for 5.5 years, 5 2/3 years. That's the nature of the benefit we're talking about. It's minuscule. So there are matters in favour and against. And as I say, I probably could do with mulling over it tonight because it's quite new to me in terms of that evidence. I think that's probably the fairest way I can put it.
Thank you. Those are my questions for Mr. Hardisman. Thank you.
Great, thank you. So we'll
Pause there.
yes, I think that's probably best.
Fair enough. Yeah.
So we shall return tomorrow morning. So sorry, what was the
I think we said 9:30 tomorrow.
yeah?
If that suits you,
What's
madam.
about leaving documents here?
Oh, sorry.
Yeah.
Sorry.
We leave documents here tonight.
Yes. Okay. But the room's locked, is it? Okay, fine. Anybody got any more housekeeping matters to raise before we finish? Okay, so we'll adjourn then until 9:30 tomorrow. The inquiry is adjourned.
Thank you very much.